May please, your lordship. My lord, may be permitted to move a very urgent, my lord, writ appeal. In fact, it's a matter of.
There is a general sentiment that the designated seniors are continuously making mentions in this court. Why is that so?
And this is the last time I'll be doing, my lord.
Okay.
No,
What is your
a writ appeal from Nagaland? Lordship was pleased to permit us on the administrative side to move it. As urgency in the sense, my lord, tenders are going to be open today. The association is before your lordship.
So we have already granted you permission.
Yes.
Then
So, my lord, today is the last date, my lord. Today is the last date of submission of bills. It's not listed, my lord. So,
I have no idea whether I've granted permission for today or for Monday.
no, my lord, there's no specific date is mentioned. Lordship has permitted, but we filed it yesterday, my lord, this in late evening.
Is there any caveat? It's a writ appeal.
Writ appeal, no caveat. As of now, we have been.
All right, get it listed today.
Deeply obliged.
Should come by 12. If it comes, then it's okay.
Yes.
By the time the board is over,
Okay, before rising. my lord.
before rising.
Lordship, my senior is out of station, so I'm appearing on behalf of Mr. D. Chaudhary. So kindly matter may be taken after,
Which matter, madam?
ma'am, Lordship, item number 1 of today's list.
What survives in this PIL? Nothing survives. NRC, CA, all have been done. That is your prayer.
Yes.
So all executions are complete. Where is your senior advocate today?
Today he is traveling to Delhi for Bar Council's meeting.
All right, re-notify on 27th as per.
Met lordship. I think I'm not 20 lordship. The senior out of station. He'll go to Delhi.
It
lordship.
stated that the arguing counsel is not available today. Arguing senior counsel is not available. Thus, a request is made to adjourn the matter. Yes, list after 3 weeks as per for hearing.
Lordship. Nice.
May it please your lordship, I beg to mention item number 85 of part 2 hearing list, lordship. May I play the matter may be upgraded and taken up on Monday or any other day next week, lordship.
Part 2 continues every day. We'll see on Monday.
Obliged, lordship.
We'll see on Monday.
Yeah, please. I beg to mention for item number 12. As per party concern, your lordship, this case may be withdrawn. As per party concern, your lordship, this case may be withdrawn.
Withdrawn.
Yes, madam.
Then counsel
Yes,
For-
Islam.
Hmm?
I am yes, Islam. madam.
S. Islam appearing for the appellants craves liberty to withdraw the instant writ appeal. Hence, the same is disposed of as withdrawn.
Mass oblige.
Daily list for orders item number 2.
SLP is pending. lordship.
Still pending. The SLP pending before Honorable the Supreme Court has referred to in the earlier proceedings has still not been decided. Thus, the consideration of the writ appeal and the IA is deferred by writ appeals and connected writ appeal and the IA is deferred by 10 weeks awaiting outcome of the aforesaid SLP.
Oblige.
10 weeks type करना है कभी मैटर में 10 weeks की जगह 10 days type check क्या yeah okay
Item number 3.
May I please lordship.
Mm.
Lordship, in this case, service was executed with the Lozima on 18/9/2023. May I please that matter may come for admission, lordship.
As per the Lavazima Court's report, comma, service has been effected. Report dated 18/9,
Your lordship.
order dated 18/9/23, comma, service upon the sole respondent has been completed. Thus, let the ITA be listed for admission.
Much.
Item number 4.
But only to the extent of that cost, not. Lordship would recollect that there was,
Was a little slight error on our part.
yes, yes.
Cost to made easy. We had indicated that we would be
Yes.
making the cost easy.
Ah.
So we'll pass that order. Okay? Any issues?
Can you be pass over the time being Lordship?
Pass or for the timing. All right.
Which matter?
Item 4.
Who named it?
There was one counsel for the private party also, Mr. Chaudhary.
Yes,
Mr. Nair.
Nair appeared, my lord.
Call Mr. Nair also. Let everyone be here. Password. Call Mr. Nair also. He's out of station. Who was his assisting counsel? Find out.
B Kaushik, my lord.
Then call Mr.
We have made
Kaushik.
the statement, my lord. He also agreed, my. Yes.
Let their presence be recorded.
Item number 5,
Lordship, 2 weeks time may be given, Lordship. Lordship, since the record is voluminous and there are 332 respondents, Lordship.
You will have to get the notice served by publication. There is no other way out.
Lordship, we have already initiated by taking photocopies, Lordship. So 2 weeks time may be given. We will first.
And counsel for the appellant is granted further opportunity of 2 weeks to take steps for effecting service on the unserved respondents. List up 2 weeks.
Lordship, can it be listed on 9th of November, Lordship?
Then 6 weeks, list on 9th November as per it.
Oblige, Lordship.
item number 6,
You are appearing for the private respondent?
Yeah, my lord, I'm appearing for the respondent number 1 to 4, my lord. But my lord, I'll be filing my power, my lord, on verbal instruction. I'm appearing, in fact,
Then counsel, your good name, please.
M. Biswas.
M. Biswas puts in appearance on behalf of the, submit that on verbal instructions, comma, he's putting in appearance on behalf of the contesting respondents numbers 1 to 4.
1 to 4.
Service has also been effected on these respondents as per the office report.
My lord, may I pray, my lord, there are 3 writ appeals, my lord, arising out of the common judgment, my lord, 3 writ
Same
petitions.
party, same
Yes,
respondents.
my lord, may I pray that all be tagged together, my lord?
The files of so and so, identical interlocutory applications and writ appeals, numbered so and so, shall be tagged and listed together on 4th October.
I have given the list, my lord.
4th October.
I'm required.
Oblige.
In the
Item-
meantime, comma, let counsel Mr. Vishwas may file wakalatnama on behalf of these respondents.
item number 7,
What is this, Mr. Gupta?
My lord. Again, I give for-
220 days delay.
My lord, delay is there, my lord.
Let's see how you have explained it. Service is complete.
My lord, name is reflected, my lord. In fact, we have served the copies to the council, my lord. There is a contempt petition also filed.
Okay.
So, my lord,
Obviously, then the council should appear.
name is shown, my lord.
Who's the council? J.C. God and Mr. Saikya. Call Mr. God.
My lord.
Basu.
No.
item number 8,
Lordship, 162 days delay, my lord.
How have you explained it?
Yes, my lord.
What is the matter on merits?
My lord, this
Date of birth.
being assured, my lord, then
No, date of birth, can it be challenged by filing a writ petition? Tell us on that.
13/6 was the, 22 was the date, and 22/12 I filed 162 days after.
Gentlemen, tell us whether a writ petition is maintainable and that too at the, after the retirement for changing the rate of birth.
My lord,
Give us one judgment on the aspect.
that is true.
Come on merits. That is true, then that is the crux of.
My lord, on points, my lord, he is a gang coolie and his identity card issued by this department is.
Absolutely nothing on merits. We are asking you on principles, why the writ petition was maintainable.
Then I'll give.
You
some
should have
time.
filed a civil suit for declaration. That is the only way out.
My lord, after. I will.
No, nothing doing. No 1 week. We will dismiss your IA as well as the appeal on merits. The 2 judgments of Supreme Court, 1996 9 SCC 407 and 94 6 SCC 302 Have a look at the judgments, list on Tuesday. Okay. The matter is deferred by 3 days so as to enable the counsel for the appellant to satisfy the court regarding maintainability of the writ petition. 26th.
Item number 9.
No, I file an IA for implement of the commissioner and secretary, my lord, to the Hill Area Department. That,
Who is appearing?
that authority used to submit the utilization certificate, my lord, for the fund, my lord. So is a necessary party.
Interlocutory application filed by Joint Counsel Mr. Barwa for impleading the Commissioner and Secretary Government of Assam, Hill Areas Department as party respondent in the writ petition is accepted. Who will be appearing? Who would be appearing on Commissioner HAD? And Counsel Mr. So puts in appearance on behalf of such respondent. He prays for and is granted 3 weeks time to complete his instructions. 4 weeks time. Amended cause title will be filed in the writ appeal.
My lord,
Let's start 4 weeks.
obliged.
In the PIL.
Yeah, my-
Copies, you already have copies. Anyhow, additional copy of the PIL is supplied to Learned Standing Council.
obliged.
Item number 10.
This is appeal by the revenue. This is the first time it has come. Lordship
We
may,
have not decided a similar matter, Mr.
Lordship, this is the another case. Lordship.
So you will issue notice then?
Lordship.
Issue notice to the respondent. Steps for service be taken. Within 7 days, whereafter process be issued.
Item number 11.
Yes, please, Lord. The matter pertains to the
Lottery.
yes. They are being hold, but they are collecting 2 crores rupees by selling 2 lakhs tickets to 100. And this way, the
This-
forest of the.
What is this business?
Lordship, may kindly have a look, Annexa 8, page 33.
State sponsored lottery.
Lordship.
A private
Get
person being allowed to do so. Is it lawful?
Lordship, I'll get the instruction what is happening. In fact, they
Yes.
have filed one representation before the deputy commissioner also.
Doesn't matter. Deputy Commissioner has granted permission.
He has given permission.
So what is the point of the representation?
Lordship, I'll get the instruction.
Issue notice MS
MD Bora,
Bora appears on behalf of all respondents.
2, 3, 4, 5, and 6.
2, 3, 4, 5, and 6. Who would be appearing for respondent number 1?
On GAD department, Lordship, they have their own standing council.
Standing counsel GAD shall appear on behalf of the respondent number 1. Service upon the respondent number 7. Is a notice to the respondent number 7 be issued and shall be got served through the SP Ojai. List for orders on interim relief. Interim relief on 28th.
Pray for interim order because lottery is going on. That's the problem.
Last date is 30th.
Yes.
So we'll take it up on 28th.
Malab.
28th.
Obliged.
28th September.
Item number 13.
Made to the lordship.
Law laid down by this court when the regularization is against personalized posts.
But my lord, the
No promotion is permissible. You would be getting benefit of ACP.
my lord,
they-
they will be stagnant, my lord.
Stagnant financially, they will get the benefits. That's the only way out. That is why that circular is there 10, 20, 30. In Rajasthan, it is 9, 18, 27.
My lord.
So that is the reason for stagnant post, you don't get financially stagnated. That is the idea behind it.
But the regular policy for regularization, it is that, my lord, they are gathered in the grade 4 cadre.
Dilip Talukdar,
Yes, my lord.
answer
My lord.
to that judgment.
Roshni, kindly peruse the first regularization order,
Hmm.
page 42.
42. Oh,
Case 42, my lord.
let's see. Have you got the financial upgradation or not?
My lord, that I do not have any instance.
Must have, must have. There's no dispute. 42,
42.
yes.
In persons, the
Newly created personal post. You never
Well,
objected to that.
grade 4 cadre.
Yes, personal,
Yes.
not a part of the cadre strength. These posts will end with your retirement.
Yes, my lord, that is
So
true, my lord,
that-
but
So there is a scope for promotion.
my lord,
There is an entire pyramid looking to the encadred post. That structure is there. You are not a part of that structure.
my lord, I will rely on two judgments of this court, my lord, wherein, my lord, even the person belonging to a personal cadre also, it is held that, my lord, the court can direct the authority to, my lord, promote them.
Why the court should? Let's see the reasoning.
My lord.
Let's see the reasoning.
Interest.
That judgment you cited before single bench. Yes, let's see. Mr. Counsel, you let us know. First, we are putting you a question that your major grievance would be ACP. In this court also, the direction is for ACP. ACP must have been granted to your clients. There is no such grievance on your part that you have not been given the financial upgradation.
Then, my lord, I'll take instruction.
Find out if you have been given financial upgradation, well, what can be done? You'll have to retire as a grade 4 employee.
But, my lord, the Roshni Kari Perus,
Let's see.
AR 1989, my lord,
Hmm.
1972, paragraph 9.
So this jurisdiction is with the Honorable the Supreme Court. Para 13 of the judgment in the case of FCI. Read para 13. Should have, these are posts which are ex-cadred posts. So ex-cadred posts, there can't be. Come to para 14 of this judgment. That's what we are talking of. ACP. Yes, FCI. ACP, the basic concept is ACP.
My lord.
So ACP will be granted. Financial upgradation will be there. There can't be any heartburn.
My lord, paragraph 13,
Hmm.
my lord,
Superior Court. It's referring to Honorable the Supreme Court. These are not cases of personal posts, basically. What was the direction in this FCI case of the High Court which has been affirmed? This was a case of regular appointment. Appointment in regular post,
My lord.
wherein the Honorable Supreme Court went on to say that yes, they were required the promotional avenues. Come to para 3, you'll get your answer. Appellant itself had approached the Union of India for creation of promotional avenues and promulgating schemes for ACP. This judgment doesn't help you. Let's see your 1989 judgment. Hmm,
9, my lord.
89, no?
Yes, my lord.
Let's see what is that. Again, that was a case of defective promotional policy. Your case on facts is totally distinguishable. Because you are persons, your employees who were irregularly appointed. One-time measure, personal post, your regularization was done. So that was an indulgence granted. How far the indulgence can be stretched? Find out whether the selection grade is being given or not.
That I'll take it.
Then counsel for the petitioner as well as Mr. D. Chaudhary appearing for the respondent authorities shall apprise the court whether benefit of selection grade has been given to the petitioners appellants over the period of time or not. What is the date of the notification? Selection grade? 10/20/30. That is how it is here.
Yes, Lord.
Hmm?
I'll take the.
Date of the notification.
How much will it be?
List on 18th October.
Item number 14.
Make 16. May I draw my lord's attention at page 31 of the writ appeal, my lord.
31 of
Of the writ appeal, my lord. That is OM dated 3/3/2016. my lord.
Yes.
If I may read, my lord. Subject relaxation of upper age limit for government jobs. Government have for quite some time been considering the matter of revision of upper age limit for entry into government services. This was necessitated mainly due to the fact that many eligible candidates have missed their chance to enter government services due to the ban imposed on normal recruitment to various services and posts for a considerable period of time from the latter half of 90s due to various reasons and circumstances. There has also been frequent prayers from various quarters for enhancement of the upper age limit. Well, this is important. Enhancement of the upper age limit for government services. In view of the above and with a view to give the deprived candidates an one-time opportunity to get into government services, government have decided to revise the upper age limit for entry into government services by 5 years from the existing 38 years. The scheduled castes and scheduled tribes and all other categories of candidates, my lord. All other categories of candidates, my lord, this was the contention before the learned single judge. My lord, wherein the learned single judge had that this would exclude the OBCs. My lord, whereas our contention was there, the next line exceptionally carves out and invariably takes out the persons who are not to be given these benefits. If I may read further, my lord, who have already been enjoying relaxation in upper age limit may add 5 years to their existing relaxed upper age limits. This relaxation would be applicable in cases of all categories of posts except, but here OBC is not excluded. Police service, both armed and unarmed, Home Guard, Civil Defense, Fire Brigade and jail services and will remain valid for 2 years from the date of issuance of this OM. There shall be no change in the procedure of recruitment or any relaxation of education or other qualification or services conditions such as year or age of retirement. This relaxation shall be applicable only to those candidates who have attained the necessary educational or other qualifications prior to crossing of the upper age limit of 38 years. The application of this OM will also be limited to vacant posts for which advertisements are made after the date of issuance of this OM.
Okay.
My lord, pursuant to this, on the very next page, page number 32, the state of Assam came with another OM, if I may read, my lord, this is a very short one. Office memorandum dated 25th of April 2018, my lord. The government, after due consideration, have decided that the upper age limit prescribed for entry into civil post services and public sector undertakings under the government of Assam through direct recruitment shall be relaxed by 3 years from the existing upper age limit in respect of candidates belonging to other backward classes, MOBCs, with immediate effect. My lord, the word immediate effect will have a bearing in my matter because, my lord, in Indra Swami, the ratio of the judgment says in under Article 16(4)(a), that is for reservation of the reserve class categories. My lord, if an OM or an executive order is issued, it is enforceable at that very moment. In my case, my lord, what has happened? This OM, the second one, 25(4)(18), came when the recruitment process did not started. It started in the month of September. That was 29th of September of 2018. This OM was very much there.
As per your synopsis, the date is 29/8/18.
18, my lord. 29/8/18. Sorry.
Okay.
And this OM was very much into that. My lord, the word
How
itself-
the single judges dealt with this OM?
My lord.
Let's see. How does the learned single judge
Yes, my lord.
deal with this OM?
Yes, my lord. My lord, he rejected the contention that is at page 180 of my para 22, my lord.
Yes.
Therefore, in the opinion of this court, the submission made by the learned counsel for the petitioner that merely because the petitioners belonging to the OBC categories are entitled to reservation and in the advertisement posts have been reserved for OBC categories, the petitioner would be entitled to age relaxation on the basis thereof is misconceived. Thereafter, my lord, at para 23. The learned counsel appearing on behalf of the petitioners further tried to develop the case of the petitioner on the basis of pleadings contained in the affidavit in reply. The learned counsel appearing on behalf of the petitioner further referring to the office memorandum dated 25/1/1995 and 27/3/12 issued by the Government of India Department of Personal Training had tried to submit that the Government of Assam follows office memorandums issued by the Department of Personnel and Training of the Government of India unless there is any office memorandum contrary thereto, and therefore the said office memorandums dated 25/1/95 and 27/3/2012 would be deemed to be holding the field till the coming of effect of the notification dated 25/4/2018. This was the one which I just said. And on the basis thereof, the petitioner would be entitled to relaxation on
So by virtue of 25/4/18,
Yes, my lord.
if you are granted 3 years relaxation,
Yes, my lord.
you would be within the time,
Within the
the age limit.
Within the
Lordship, with the Assam Public Service Commission has rejected its candidature because during that time of advertisement and till the last date of advertisement, she is not eligible as per the OM dated 3/3/16, Lordship. Though the next OM dated page 32 has came into force, Lordship, it is give immediate effect. So
Then-
if we revert back the clock to his Lordship, the another genuine candidate would have been deprived, Lordship. And no instruction from the government to give the retrospective effect of that OM, Lordship.
What is the date of the recruitment notification?
Lordship, his Lordship would find page 25 is the advertisement,
Let's see, just hold on. Page 25,
page 25. Lordship. Is the
17th February.
advertisement 17 February 2018.
Okay.
And Lordship would find the last date of advertisement is at page 29, Lordship. The last date of receiving duly filled up application from the commission office.
Okay, and what do you say about the OM of 2016? Why is it not applicable to OBC
That
candidates?
OM is 16 is applicable to ST and SC candidate, Lordship.
No, SC/ST candidates get 5 years
5
additional.
years, Lordship.
So they get additional 5 years, but the other candidates, they also get the relaxation.
No, Lord-
Other category candidates, read the OM properly. Let's see, once again. At page number?
page number 31, my lord.
Page 31, Lordship. So it says, government have decided to revise the upper age limit for entry into government service by 5 years from the existing 38 years. The scheduled caste and scheduled tribe candidate category of candidates who have already been enjoying relaxation in upper age, it may add 5 years to their existing relaxed.
So that is an additional 5 years
Additional.
to SC/ST and other reserved category. But the plain reading of this notification is the extension is being granted on the age relaxation is being granted on the ground that there have been gaps in making the recruitments. So persons become age barred. This is not restricted to SC/ST.
But they,
SC/ST and other reserved categories, they get an additional buffer of 5 years.
but my humble submission is that
Hmm.
if that OM covered the OBC, then that OM page 32 would have not been lordship clarified, lordship.
Forget about 32 you yourself say is not applicable because it came into force subsequently.
Subsequently, lordship.
All right. So what about 16? Why 16 is not applicable?
16, there is no mention for ABC, lordship.
For
No, there is no mention about the OBC and MOBC.
it's a general category even. Relaxation on the ground that there is a gap in issuing the notifications for selection. So people as a whole.
Lordship.
Read. Government has for quite some time
Quite some time have.
age limit
the-
for entry into government services. So this is not restricted to any particular category. Understand? This was necessitated mainly due to the fact that many eligible candidates have missed their chances to enter government service due to ban imposed on so and so. So as a matter of fact, in Rajasthan, there are specific notifications for services wherein there is a gap of more than 2 years.
Lordship.
There is an automatic age relaxation to the candidates
Lordship.
who have crossed the age limit in the intervening period. That is what the intention is. It is not restricted to SC/ST.
But government has not also clarified the Assam Public Service Commission in their respect, lordship.
Hmm?
They have also filed affidavit, lordship,
Yes.
that government inspection is very much necessary in this case, lordship. They have to clarify the APSC.
They have to.
Clarify the APSC, how.
What is the government? Government did not file an affidavit.
One.
Already issue notice to the respondents. Mr. Your good name, please.
H. Bitalam, no? H. Bitalam.
H. Betalam is your good name, please.
PP Datta, lordship.
PP Datta appears for the APSC.
APSC, lordship.
Who is appearing for the others?
And for 1 and 3, lordship, confirm correct. Number 2 is anyway. There are separate spelling.
MS Boda appears on behalf of the respondents numbers 1 and 3. Standing counsel for respondent number 2.
Sorry, lordship, 101 is the affidavit of government, lordship.
What the
101.
comment says, let's see.
11 is 102, lordship, paragraph 5. That with regard to the statement made in paragraph 5 of the writ petition, the deponent beg to state that the government in personnel department.
Yes, all right.
So-and-so.
Expired on 2/3/18.
Lordship.
Expired means what? It would
Regarding-
definitely be applicable to the, either you give benefit of 18 or you give benefit of 16.
Finally, lordship, may I
Yes.
able to read, lordship? Regarding the relaxation of upper age limit for government job by 5 years from existing 38 years for a period of 2 years from the date of issue OM. The term of condition of OM expired on so and so. The said advertisement of the Assam Public Service Commission was issued on so and so. Since the advertisement was issued before expiry of the OM dated so and so, the upper age relaxation as per OM would be applicable as on so and so. Applicant up to age of 38.
So very clear. This is very clear.
Were eligible to apply for ST and SC and other categories enjoying existing relaxation. The number of years such relaxation would be added to 40 years.
So 5 years would be added to 43. That's what we are saying. All candidates across the board, age relaxation was provided. And that since your advertisement was issued during the live period of 2016 notification, they get the benefit.
Next paragraph, lordship, may I read?
Yes.
It is seen from the writ petition, paragraph says that petitioners caused the
Okay.
age for 43 years as on 1/1/18. For OBC MOC candidate, there was no other existing relaxation in the upper age for the entry into government job. At
All
the
right, they
time of the
crossed 43 by 1/1/18.
Lordship,
Yes.
the contention of the petitioner that the
Yes,
other
that-
papers committee
all
has
right,
been availing 3 years. Lordship.
Hmm.
3 years of upper age limit in appointment process since long is not true. The said benefit of 3 years regarding upper age relaxation given to OBC MOBC candidate came into force only 25/4/18. That is date of issue of OM dated 25/4/18. As such, as on 1/1/18, the OBC and OBC candidate were not eligible for the benefit of upper age reduction of 3 years. This is the case, sir.
My lord, may I take my lot at page number 45 of my writ appeal, my lord, where I have drawn the, my lord, specifically 44 was the. age
Mr.
when this
Vitala,
person has-
first thing,
My lord.
any kind of relaxation to OBC simpliciter is not contemplated in Indrasani.
My lord.
It has to be OBC economically backward. So otherwise also we have made it clear,
Yes, my
the entire selection process was affected by that.
lord, but this was not the ground wherein, my lord, this, my lord, the round was there. My lord, 44 was the age when this person has got this selection, my lord, the date when he entered into this. My lord, 43 plus 3 years would be added to him.
Plus
That
3
was
can't be
my
added,
question.
sir. Plus 3 can't be added. You already have been given 5 years relaxation.
Yes, my
The subsequent notification came into force after the issuance of the recruitment selection notification. Can't get it. Dismissed. The order is up. Third order is up.
My lord.
Yes.
You know, here is one of the district judiciary. 48 same application was there. OBC has been given. 48
Negative
plus
equity.
My lord,
Negative equity.
no, my lord. Similarly situated persons, my lord, OBCs were there. My lord, there the state government come with that same OM stating that this is also 2016. If I may place it.
Let's see. Let's see.
My lord, there the election went for 48 years.
That's misconceived as a matter. If it has been given, it has wrongly been given.
My lord, if I may take my lord to the page 4 of 17, top.
So the Guwahati High Court may be misunderstood.
My lord, that is.
That's right. We are saying so.
My lord. At para number 2, my lord, serial number 2, my lord. OBC 18 and the outer limit is 46, my lord.
That is a
So the
wrong
OBC and
interpretation. Wrong interpretation.
My lord, even then, my lord, 3/3/16, my lord, the upper age limit. The word they have used is the enhancement of the upper age limit. My lord, when it was 43, the existing OM. of
43,
2016
your, at the time of issuance of 2016, your upper age limit was 38.
38.
Of anybody other than SC/ST was 38.
Hmm.
So 38 plus 5, you cross that on 1/1/18. That's the simple interpretation of this issue.
My lord, in my respectful submission, if I may just said, my lord, I'm
Take
taking.
note
part
of your
my-
arguments.
My lord, if I may read this part of that. OM 3/3/16, my lord, what it
Read,
says,
read,
it was the
sure.
enhancement of that.
Yes, read.
Yes, my lord. Government have for quite some time been considering the matter of revision of upper age limit. My lord, this is a revision in fact, my lord, because there was already an existing.
What was the age limit for candidates other than SC/ST before issuance of this?
My lord, that was 38.
That's it. So it has been revised now. The intention of 2016 is very clear that SC/ST and other reserve category candidates, OBCs were never given reservation. If they have been given, it is wrong, illegal, unconstitutional. So only reserve category candidates got an additional buffer of 5 years.
Yes, my lord. My lord, now a consent.
And we have a loud approval of Mr. Chaudhary in this. We don't have any case, sir. Thank you. That's it.
Yes.
Item number 15.
Yes.
Here the petition before the lordship.
This is the transition has to come in, sir. There is no way out. This is a policy decision.
Yes.
I know, my lord, but the certain parameters are there, the Supreme Court, my lord, court cases are denied. Where, my lord, that to be, my lord, testified that whether this was done in that way or, my lord, in other way. Because, my lord, first of all, my lord, this provision, whatever is trying to brought that by digital, my lord.
You let us know what will happen once the e-filing start 100% in the High Court.
Yes.
The clerks will face the same difficulty.
100%, my lord,
That
100% is a very.
That is a cost of automation, cost of digitization. We can't help it.
My lord,
Everyone has to
But they.
face that or suffer the
But
consequences.
so far, my lord, the other person who are involved in the, my lord, this profession, my lord, by selling the stamp, my lord, they are earning.
We understand,
But
we have
lordship says
sympathies.
The fate of these people. my lord.
Sympathies, can they override the policy decisions?
No.
Then
I'm not on that, my lord. The
Then-
policy decision is very limited, my lord. This is already clear.
all right, let them
Many
respond.
cases, my lord.
At least we will at least
My lord,
entertain
one-
your writ petition.
My lord, one pair, my lord, one thing. my lord.
We are not staying anything,
My lord,
sorry.
from my lord, because of the selling, stopping of the sale, more than my lord, 500 crores, my lord, the stamp.
You
duty is like-
redeposit. You
No, no, no,
redeposit.
it is with this GOP exchequer, my lord. It is with the GOP exchequer, lying, my lord.
So all right, they
So
will,
I paid my.
so
lord.
that is paper.
Let the my process where to be.
That is paper.
Exhaust my lord, these things.
That's again their policy decision. The same argument can come for the 8/11/2016 decision. Same argument.
My lord, the act is, my lord, not provided this thing that it will be solely, my lord, digital. This is a purely, my lord, contradictory of this provision, but this is I.
Let them reply then. Let their affidavit come. Issue notice.
Section of 1 lakh rupees is also given as subvention. Your
Well, 1 lakh is I paid, my lord, 1 lakh rupees for, my lord, the upgradation of my lord, to the, my lord, digital, my lord, stamp, my lord, vendor stop. It is not sufficient because, my lord, I have to purchase one, my lord, computer, then printer, then other.
1 lakh rupees, what you have done?
1 lakh rupees is
As
not
subvention, your lordship,
for subventioning
been
my
sanctioned.
existing, my lord.
as a subvention for establishment in common service center
Hmm,
for selling the digital stamps.
okay. You've been given that opportunity, sell digital stamps.
My lord, all over, my lord, total 36 states, my lord, the 12 has not adopted this, my lord, this, digital. My lord,
Let's-
other 20 have adopted. including,
Let's
my
have
lord,
their
the-
response, then we'll
both-
see.
The only
issue
the
notice.
Punjab till that, my lord, they have adopted. The Assam will be the second, my lord.
MS Bodloi puts in appearance on behalf of the all respondents.
Yeah.
Respond number 1, who would be appearing for
I am for 2 and 3.
respond? Mr. Sharma appears in on behalf of response numbers 2 and 3. Copies of the writ petition be provided to Leonard. There is one more, 4. Who's 4?
For, my lord, is, my lord, stock holding, my lord. My lord, why this is also, my lord, I will come to that, my later, my lord. Stock holding is giving the, my lord,
Corporation.
state authority to deal with the, my lord, stamp. So they are giving, why it is.
Steps for service on the response numbers 4 and 5 be taken in 3 days, whereupon process be issued to such respondents.
Other vested interests also there.
Copies of writ petition be provided to Leonard Standing Council. Rule is made returnable in 6 weeks.
Master, please.
I'm obliged.
Item number 16.
In this case, my lord, the department has already filed their affidavit. On the last occasion, my lord, there was a directive to file, reply by the petitioner.
Do you want to file reply, sir?
Yeah.
Are you intending to file reply?
No.
My lord,
No,
The state government has not filed it.
my lord, we have not filed the affidavit. Sometime maybe.
you have not filed.
Not filed.
Why?
The department has filed.
2019.
My lord, somehow it has been, my lord, miscommunicated. my
All
lord.
right,
I have
Learned,
gone through-
additional senior comment advocate, Mr. Sharma. Praise for and is granted last opportunity of 4 weeks to file affidavit on behalf of the respondent state government.
Yes,
Respondents numbers 1 and 2.
1, 2, and 3.
3 is transport department.
Careful.
Transport has filed 1 and 2. The affidavit will be filed positively within next 4 weeks. Counsel for the petitioner may file affidavit in reply, if so desired, to the affidavit in opposition in 3 weeks thereafter, list after 8 weeks.
Obliged.
Item number 17.
Yeah, please. Lordship, regarding same issue, my lord, the 3 writ petition is pending before the single bench, my lord.
Before the,
Before the single bench, my lord.
your writ petition was dismissed as being premature,
Yes, my lord.
Then-
Regarding same issue, my lord, 3 other writ petitions pending.
are
before-
pending.
Yes.
Where is the number?
Number is WBC number 855/2023. Writ petition number 147 of.
And we'll call those files and examine what is happening.
Yes.
And counsel for the appellant submits that though the writ petition of the petitioners was dismissed on the ground of being premature, comma, the fact remains that 3 more writ petitions, number so and so, are still pending before the learned single judge. In this background, the registry is directed to present the records of the said 3 writ petitions for perusal of this court on the next date of listing. Re-notify this writ appeal on 18th October.
Most of it.
You give a list.
Item number 18.
May please, my lord. My lord, may the matter be passed over for the time being. The conducting counsel is on legs. After some time, my lord,
Password.
I'm obliged.
Item number 19.
May it please your lordship. Lordship, by the last order, I directed the state government to provide us with a copy of the report of
Reports.
all the institutes. This is what has been provided, my lord.
But the report has been submitted, my
This
lord,
is
along
the
with the affidavit. Lordship may kindly see my affidavit, my lord. Wherein, my lord, it has been explained. A copy of the, my lord, affidavit in opposition has already been served,
Why don't you place the original reports on record?
my lord.
Why you are shying away? Why the actual reports are not being filed?
This is the report, my lord.
This is the only report.
This
My
is the report served, my lord.
What is the report? Let us see.
My lord, this is the same thing as it is reflected in page number 77. Page 77 of the running page number. Page 77, the affidavit file.
Hmm.
I had drawn your lordship's attention to this particular report on the last occasion as well.
This is consolidated statement as a matter.
Yes, my lord.
Hmm.
And after direction to furnish the complete report, also the consolidated statement only has been provided. And my lord, from the consolidated statement, it is absolutely clear.
Yes, you had pointed out that there are some samples which are containing that formaldehyde.
Formaldehyde and some samples are containing cadmium.
Cadmium also, arsenic also, yes.
And my lord, the state government is not showing any measures which have been taken to prevent this kind of thing.
What have
because,
you done?
My lord, the right to health is at
Lordship may
stake.
kindly see my affidavit in page 27, also paragraph 4, my lord.
Yes.
My lord, after receiving the report, the Director of Fisheries Assam has,
These reports were received
my lord,
in December, April, May. After that, what has happened?
my lord, the
You were
appointment
to,
of
you were to
district-
get fresh reports done.
This was the last report, my lord.
Ah. Ms. Sharma,
What steps we have taken, I would like to, my lord, to highlight you before long.
you said that all right, collect samples and keep on testing.
My lord. And
Where are the
nodal
fresh
officer
reports?
He appointed district wise, my lord.
We understand.
My lord.
Thereafter, what has happened? Follow-up action.
My lord. That follow-up action, we have to take inspection, my lord.
All right, provide her the original reports, copy of the original reports.
Original.
We want we have already given twice the direction. Despite pertinent direction given by the court.
My lord will kindly appreciate one thing. The prayer for stay has been pending since the month of April, my lord.
Stay on import.
My lord, at least for the time being, I have also filed an additional affidavit before this honorable.
Have you suggested any alternatives, how they will manage the supply? This is a food
My lord,
article,
local-
staple food article.
Local fish is available, my lord. Local fish is available.
Covered, more than 30%.
Whether it would completely cover the requirement, we don't know.
But
We are
my
not bothered as a matter of fact.
My lord, the right to health of the citizens.
We understand your anxiety. But the question is whether starvation is better or managing with these things is better.
Starve.
You know,
They
you
at the moment
will,
not eating fish.
will-
But there are a number of variety of food items which are already.
yeah, that's right. We tell you, madam,
Yes,
that we will be very happy. But larger populace of the state will not be so happy by that. view.
There is another PIL which relates to vegetables also. In that
Hmm.
particular matter also an interim protection has been granted.
What interim protection has been?
My lord, I'm not very sure. I got to know just today morning from
Hmm.
one of my colleagues.
Hmm.
Some interim protection has been granted in that matter also.
All right, we'll consider your prayer on the next
The
day.
state of Meghalaya also, my lord, will kindly appreciate. In the state of Meghalaya, the majority of the population is the tribals of the state of Meghalaya.
Hmm.
And I had filed an additional affidavit.
All right, tell
Vendors
us,
can record a
tell
ban.
us, tell us. What is the proportional consumption of fish procured locally and the imported fish? What is the ratio? Tell us, any figures?
My lord, the figures were there in the newspaper according to the,
Let's tell us, please. These are in vernacular. Help us out.
there was one particular news report in
Have you got the
English
statistics,
also,
Ms. Sharma?
because I myself also
My
cannot
lord.
read Assamese.
That, my lord, accurately, we cannot say, my lord, but it less than 30%, my lord, local product.
Local production is less than 30%.
Less than 30% of the demand.
My lord will appreciate one more thing. My lord, when this issue was highlighted in the newspapers, the Honorable Chief Minister of the state had made a statement in Delhi that we will carry out our own investigation through the other 4 institutes. And if it is found that heavy metal is found in the fish, then we will take appropriate action and stop the import of such fishes. in
Heavy
the
metal
state.
has been found only in one report.
My lord, in
That
My lord,
cadmium and arsenic.
my lord, formaldehyde also, it is more than
Not
3 times.
Not a heavy metal, madam. It's a big difference.
My lord,
Hmm.
it's formaldehyde also, my lord. the
Yes, it is
quantity
harmful.
More than
No,
3
no,
times.
It is a hazard, definitely.
And
We
my
don't,
lord, it is more than 3 times the quantity that.
let us, all right, let us have the latest report. In terms of their affidavit, what is the subsequent follow?
A deadline may be given,
All
my
right.
lord, because since April now it's end
Yes.
September.
On a perusal of the MS Agarwal and counsel representing the petitioner urges that as per the affidavit filed by the respondent state authorities, pursuant to the test reports charted in the affidavit, a specific direction was given to the district nodal officers were appointed for monitoring and carrying out regular sample collection from the fish market in their respective jurisdictions and formalin detection kits were also distributed. Full stop. She urges that till date, no latest report regarding tests carried out, if any, pursuant to the said instruction has been placed on record. She further urges that detailed reports of which the consolidated chart has been presented in the affidavit have not been provided to her despite pertinent direction given on the previous date. Mr. Sharma is directed to ensure that the reports in original as referred to in the affidavit of the state government are provided to Learned Counsel representing the petitioner. Full stop. The steps, details of the steps taken, if any, by the nodal officers in terms of amendments made at para number 4 of the affidavit shall also be placed on record after supplying copy thereof to Learned Counsel for the petitioner. Re-notify on 18th October.
Obliged, my lord. My lord, may kindly note that no adjournment may be sought on 18th October regarding the reports. Because it's a long
May I
period.
pray,
they
my
take.
lord, this may be, my lord, listed after Puja vacation, my lord. This was, my lord, received by me on 4th of August 2023.
Mr. Sharma, the petitioner is trying to highlight the plight of the people who are eating this contaminated fish. Why you are trying to delay the things?
My lord, as per the affidavit, my lord.
4 weeks time is more than enough.
Permissible limit, my lord. The test report has come out with that, my lord, preservative is in permissible limit. That
No,
is
there are a few samples which are containing 3 times.
A few, my lord.
Then get the reports 18th October.
Not if I am appearing for Andhra Pradesh Fish Farmers Association, what has happened? The petitioner is asking for ban on imports. So what has happened? The fish which comes from Andhra Pradesh goes through various stages. Now, at what stage the formalin fish is food that is also a question to be looked into, Lordship, because maybe because our fees, the way it is packed, it is tetra packing. Therefore, the fees for 8 days, it remains fresh. Therefore, there is no requirement to put formalin. Therefore, Lordship.
You filed your affidavit?
Yes.
Yes, ma'am.
All right, we'll see. We'll see on the next.
Plus, I appear for respondent number 4, but copy of the reports may also be provided to us. Copies that will be taken.
Copies of the reports shall be provided to counsel for the correspondence as well.
Obliged, ma'am.
No.
Possible meter, item number 4.
Has anyone come on behalf of Mr. Nair?
I'm appearing for private respondent, number 6, my lord.
So that, as a matter of fact, there is an error
Yes, my
we
lord,
feel-
to the extent of my lord cost. We do
to
not
the
pay
extent of
interest.
cost. All right. Dispose.
Obliged, my lord.
Item number 7.
My lord, there is a delay of, my lord, 222 days, my lord.
I'm appearing on behalf of Mr. J.C. Gaur for respondent number 1 to 150. Lord.
Yes. What do you say on delay condonation? Should not be aware.
My lord.
And counsel for the respondent, praise foreign is granted. 2 weeks time to file affidavit in opposition.
Yes, Lord.
Objection in the application seeking condonation.
My lord.
Placed after 2 weeks.
Obliged.
Item number 18.
May I please, my lords?
Mm.
My lords, in this matter, on 10th May 2023,
Mm.
my lords had directed that writ petition 8024 of 2022, which is pending, to be heard.
Mm.
So a fixed date has been given in that matter, my lords, or that is 14 November.
Mm.
So the matter can be taken up in the last 4th week of November or first week of
This
December.
court is apprised that next date fixed in WPC number 80/22 is 14 November,
14 November 2020.
14 November 23. Thus, legislative appeal will be listed after 10 weeks. Awaiting outcome of the aforesaid writ petition.
Obliged.
Supplementary cost this item 23.
May I please, your lordship?
Mm.
My lord. Yesterday, my lord, there is a delay of 221 days and.
What is the delay in filing the writ petition, madam?
My lord, I am aware of this.
Then-
And my lord, my lord, with due respect, it is with regard to compassionate event. The person before your lordship is with regard to compassionate event. Because of financial reasons, my lord, this is one of the reasons he went for. My lord may take it with little leniency. That is my prayer. My lord may consider it with little leniency with regard to.
What for, madam? The concept of compassionate appointment is contrary to the general principles of employment.
My lord.
So that is an exception. It has to be done in an exceptional
My
circumstance.
lord.
And if a man is sleeping over his rights for 10 years,
My lord.
then where's the question of granting that?
With regard to that part, my lord, he has approached the respondent authorities, but he has not approached, my lord, with regard to that policy decision. Since all cases, so he was only praying not with regard to merit, only some consideration to put his application.
His application was dismissed long back,
His application, yes, in the year 2010.
10. So then if you're sleeping over that application, taking no action, you are going to Arunachal Pradesh, this and that, there's no
My lord,
justification.
With regard to that aspect, with regard to 2010 application delay, with regard to writ petition, he has approached the respondent authorities and thereafter he has come over there. But with regard to this IA, he was in Arunachal Pradesh. with
No,
regard
that's
to
okay. IA may be all right,
that.
but
With
even
regard
on
to-
merits, you don't have a case.
My
So
lord,
why condone delay? Thank you.
Much obliged, my lord.
Discuss. And the rate of on merits.
Item number 24.
May please, Lordship.
Yes, please.
Lordship, my friend for the cabinet as well as the government is on joining by a DC, my lord.
Yes,
Yes, my lord, we are joining it from here.
yes, yes, please.
That's my lord. Lordship, about challenging the Lana single judgment, the probability of the impugned judgment order. Lordship, we can have a look at the para number 29, page number 63.
Yes,
Page number
please.
63, what it says, Lana single judge says, the Lordship. Petitioner appellant cannot show that he ever was appointed as vice chairman of the ADC Ukhrul.
Mm,
But he was never appointed as vice chairman of ADC Ukhrul. And the Lordship, the Lana single judge only says that the letter issued by the chief executive officer Ukhrul, that is one also is a mere communication between the CEO ADC Ukhrul and the principal secretary. Presuming on the ground, the Lordship, the lead petitioner appellant was never appointed as a vice chairman.
Mm.
And the Lordship, communication regarding the information given to the authority about the election appointment of the appellant lead petitioner as vice chairman. Lana single judge only says that it is a mere communication.
mm,
Lordship, may kindly be noted that Lordship, under the ADC rule, under Rule 3 and 4, Rule 3 is regarding the appointment to the post of chairman. And the chairman is conducted by the state government. But in respect of the appointment to the post of the election to the post of vice chairman, it is done by the council itself.
mm,
And therefore, Lordship, whenever there is a election held and the one person is elected,
mm.
that is communicated by the chief executive officer of the council to the state government. That is a document. May I take my look to page number 107. Page 107.
Right.
Lordship will find that that is on 21st December 2017. It has the Lordship is directed by Chonosho, election of vice chairman of Ukhrul.
Mm.
Autonomous District Council was held at the central hall of Autonomous District Council Ukhrul on 20 December 2017 with Chonosho. Sri Am Ija, the present appellant, great petitioner, sitting MDC from Chonosho was elected uncontested as vice chairman. It was proposed by the executive member, B.L. Khamer, sitting Chonosho, and second by Chonosho.
Mm.
This document, Lordship, established the Lordship that this man was the vice chairman.
Mm.
But Lana single has just said this document, this communication is merely a communication between the chief executive officer
Mm.
and the state government, thereby ignoring that the appointment of the present appellant elite petitioner as a vice chairman, Lordship, has not been accepted by the Lana single judge.
Yes.
This is the one point. Another point, Lana single judge has said the Lordship. This hence the term of the ADC was expired in 2020,
Mm.
Lordship. Applicability of the Rule 9, Lordship, is not acceptable for the reason that Rule 9 will apply only when the term is continued.
Term is continuing.
Yes.
Yes.
The Lordship, the peculiarity in this case is, Lordship, 2017 to 20, that is term the ADC. And at that time, Lordship, election could not be held because of various reasons which cannot be explained by the state government.
Mm.
The Lordship, after 2020, in terms of rule section 47,
Mm.
it is extendable by 1 year,
Yes.
Lordship. And the 6 months was extended.
Mm.
That the Lordship, no extension was met, even though 1 year is a met, 1 year is a permissible.
Mm.
The Lordship, the ADC persons approach the authority, why not extend till the
Mm.
election is held?
Mm.
Instead of doing
But whether that is permissible in law,
that
extension beyond 6 months or 1 year as you
1
say.
year, 1 year.
So is it permissible?
Yes, under the Rule 47, 1 year is permissible.
Okay.
After extending 6 months, Lordship, then the Lordship, then an order was issued, Lordship, the supersession of the ADC on Lordship 13 November 2020.
So that became final, that was
No,
not challenged.
No, that was challenged.
That was challenged.
That was challenged.
In which matter?
That was challenged. That the petition Lordship will find, and Lordship may take my lord to in 3 writ petition that was subject matter.
Mm.
May take my lord to Yes. Is 110.
Yes, just.
NSA 5. There are three writ petitions, Lordship. WPC number 613, WPC number 645, 647, Lordship. And the
What is the
Lordship,
status of these writ petitions? They have also been decided?
Lordship, it is decided. May I take my lord to page 121, WPC number. The instant writ petition came to be filed, questioning the validity and the correctness of the order issued by so and so, so and so. In addition to that, it has been prior to directly so and so, so and so, so and so. Lordship. And the Lordship learned a single judge, Lordship. When it was heard for the first time, pass an interim order, which Lordship will find at para number 4. Para number 4, 118. On 27/11/2020, when the writ petition came up for consideration, this court while issuing notice to the respondents passed an interim order directing that term of the district council in respect of the hill area be extended till 4/12/2020, for which state government should issue necessary order, Lordship. Lordship, when learning single judge after examining the records and the Lordship, the conduct of the authority, Lordship, finally come to the conclusion that Lordship, may I take my lord to page number 138, my lord. 138. May I read, Lordship, with permission?
Yes.
On perusal of the order dated 13 November 2020, impugned herein, it is saying that only reason given therein for supersession is that the term of the district council will expire on the same day. The administration of the district council can be carried out in accordance with the provision of the Act 1971. Shri Honest Hall and its council, relying on the decision rendered by the Honorable Supreme Court and so on and so, contended that election ought to have been held in time so that motion of supersession would not have arisen. It could not have been avoided in so and so it has been held at the part of the State Election Commission in respect of the conduct of the election. Not less than the Election Commission in their respective domains. The State Election Commission shall try to complete the election before the expiration term and shall not yield to a situation that may be created by vested interest to postpone the election from being held within the stipulated time. Any revision of the electoral roll shall be carried out in time and cannot be carried out with the reasonable time the election has to be conducted on the basis of the then existing electoral roll. After skipping this, Lordship, may I take my lord directly to page 140. I read, Lordship, about 5 lines from bottom. On top of that, Lordship, on top of that, it may be noted that on so and so, when the writ petition being so and so came up for consideration, this court passed an interim order directing that the term of the district council be extended till so and so, and that the necessary order should be issued accordingly. Instead of issuing an order extending the term till on so and so, the interim order was issued superseding the district council, which is contrary to the interim order that is passed by this court. In the word, the interim order which has violated the interim order of this court is bad in law in being the unsustainable and liable to be quashed and set aside. No material has been placed on record by the state government that the interim order that is has been quashed and set aside by any appellate forum. For the reasons stated herein above, the petition being so stand disposed of with the observation made herein above so are followed, and consequently the interim order that is is quashed and set aside with the following direction. State government and in particular, Additional Chief Secretary Government Manipur shall write a letter to the Hill Area Committee, Manipur, seeking its opinion as to whether the term of the district council shall be extended or not till the completion of the election. The said letter shall be written within a week from the date of receipt of the copy of this in order, judgment order. On receipt of this such letter that is the Hill Area Committee, Manipur Legislative Assembly said furnish his opinion within a week from the date of receipt of the letter. After the opening the Hill Area Committee, Manipur Legislative Assembly being duly received, state government shall take a decision issue an appropriate order immediately in terms thereof. Till such an order issued by the state government, as mentioned in direction the interim order that is shall continue. Lordship. Lordship, the situation is.
This order was not
the state
challenged.
government has not passed any.
This order was challenged or not? Single bench
This order
order?
is challenged with appeal, but no stay is granted.
No
It's
stay.
still pending.
Okay.
In other words, Lordship, this order is operating in
Continuous
field.
toll field.
Is it Lordship?
All right.
Lordship, any order passed, Lordship, in the past, in any interim order, it is nullity in the eyes of law. This is held in a number of cases, like Rabbi Naik Lordship, many others Lordship. So Lordship, as part of judicial order, as on today, this order is subsisting, Lordship. But whatever the case, Lordship, the government, instead of allowing the agency to perform, Lordship, they issue an order by cabinet decision, Lordship, to allow the chairperson of the ADC to act as the acting chairperson, Lordship. Then Lordship, there was allowed, and the Lordship, that was again rolled back. That was again challenged. And the Lordship, the challenge, Lordship, the person was allowed, stating that till notification for elections is held, they should be allowed. That order was complied with by the state government by issuing an order on 14 March 2023. That order, may I take my lord to that order?
Yes. At page number.
Yes, Lord, sir. Sorry, I'll take Lord, sir, today. Yes, may I take my lord to page 57. Compliance of the order passed by the learned single judge allowing the writ petition rolling back the chairperson to act as a acting chairperson, Lordship, it is complied with by this order on 14 March 2023, Lordship. And the Lordship thereafter, in respect of the occurring, Lordship, that the acting chairperson, he resigned in the meantime. Because of that, there is none. And the Lordship, when the chairperson is not there, in terms of the condition of Rule 9,
Vice
Lordship,
chairman should be there.
Vice chairman, that is the condition. But what is the government has done? Page 158, Lordship. One member may read the last paragraph. Paragraph no, 155, 58.
55.
Yes, that was the impugn before the learned single judge, Lordship.
Yes, that's
27 March 2023. Paragraph
155.
Paragraph 5, may I read? Page 158, man.
158.
Yes, 27 March 2023. I read only paragraph number 5. Lordship, I think I read as a whole, so it will give the clear picture. Whereas the Travel Affairs the Health Department orders on the show, honored government is pleased to allow the last constituted care. I'm emphasizing on this word. Last constituted caretaker chairman of the Autonomous District Council concerned to function as caretaker chairman till the issuance of notification for the election of Autonomous District Council Manipur. This was issued in compliance with the honorable post order that is shown. Whereas Dr. Yorosang Ngalong has done the resignation from the office of caretaker chairman Autonomous District Council. Whereas the government had accepted his resignation by Chonaso. Whereas in continuation of the government order of even number dated 14 March 2023, Lordship. In continuation, that is the compliance of the order of the
High Court.
Yes, High Court, allowing the caretaker chairman to function as caretaker, Lordship. In continuation of the order, the government is pleased to allow Sri Mark Luting, member of the last constituted ADC Okrur, to function as caretaker chairman, ADC Okrur, till the issuance of notification for election of Autonomous District Council, Manipur. This order was impugned before the learned single. I challenged it on the ground, the Lordship. This order is in contravention of the Rule 9. In as much as under the Act, ADC Act as a rule, there is no provision vesting the state government to any empowering state government to issue this kind of order. The state government has no discretionary power to issue an order when there is a statutory rule enforced in the field matter. That was a submission. And the Lordship, the learned singles at the time, Anderson was pleased to pass an interim order, which I may take Lordship to page number 69. Page number 69. Yes, that was passed on 3/4/2023. Lordship, this was the second hearing. Already interim order was passed. Thereafter, I take directly to Lordship, para number 6, page 70. Pursuant to the order dated 19/1/2023, government also passed the order dated 14/3/2023. That is the order I have taken your Lordship today, compliance order. And admitting the person who are functioning as caretaker chairman, the members directed to continue till the issuance of the notice of the election of ADC Manipur. Therefore, he further states that present impin order has been passed by Deputy Secretary, TNT Hills Government Manipur by one Mark Luiting, that is responsible number 4, has been appointed and allowed to function as caretaker chairman ADC Okro. The said order that is shown so has been challenged by this person. Since the said order was passed against Rule 9 of the Manipur Hill Area District Council Rule 1972, this reads as follows. Rule 9. For the vice chairman or the person to perform duty of the office or act as chairman. While the office of chairman is vacant, duty of the officer shall be performed by the vice chairman. During absence of the chairman from the meeting of the council, the vice chairman, or if he is absent, one of the deputy chairman shall act as chairman in accordance with the provision of Rule 5. Lordship. Then, Lordship, that para 9. Admittedly, Rule 9 of the Manipur Hill Area District Council Rule 1972 is clearly provided that if the post of chairman is vacant, vice chairman would take the function of chairman, particularly autonomous district council, by violating the provision of Rule 9 of the Manipur. So. Therefore, the issue notice so till such time, the third time, there shall be interim order staying the operation of the impin order that is so. Lordship, at the juncture, learning single judge would view that Rule 9 is the applicability rule in this field, and therefore.
That was an interlocutory order, sir.
Yes.
It was not a final opinion.
Yes.
And
And
what
in the final
just-
order, what the learned single judge says, Lordship, Rule 9 will apply only when the ADC is
if the council is in
is
force,
continuing in
is still continuing.
And therefore, whenever it is not there, state government has the discretionary power, which I say no. Because for the reason that Lordship, the picking up this man, Lordship, this man, one of the member, Lordship, it is never contemplated anywhere under the law in the field, number 1. It is a weakness, Lordship. Number 3, Lordship, government cannot have a discretionary power when there is a rule. Number 4, Lordship, that is judicial order in force, Lordship. Right or wrong, Lordship, whether government complied or not, Lordship, it is an order, judicial order passed by High Court, which is still in force, which is not altered, Lordship, or modified or quashed by a competent higher court, Lordship. And therefore, on the fascist order, this learned single judgment is sustainable in the eyes of law. This is I'm questioning. And only the stand of the
How
state
does,
government.
just, Mr. Senior Counsel, how does this impugn order take note of the earlier order passed in that batch of writ petitions, 19-123? How has it been dealt with?
Lordship, it is not, I think, it is not discussed, I think.
It's not discussed?
It was, Lordship,
It was not even referred to as per you?
made, my lord.
Just check, please. All right, one more question.
Yes.
By virtue of this stay order,
Yes,
which was passed in this writ petition,
yes, ma'am.
what happened? What was the consequence in the intervening period?
Lordship, in the meantime, Lordship, nobody was functioning,
Nobody was functioning.
because the interim order.
Okay.
And I filed it, there was no bench available, so I filed transfer petition,
Oh, that's okay.
SLP, and the Lordship, the Honorable Supreme Court, Lordship, in one of the most peculiar form, directed me to file the appeal directly in this High Court, my lord,
It's okay.
under the Guwahati High Court rule.
Mm.
I do not file any transfer petition. I file SLP,
Mhm.
having regard to the privacy of the order.
We understand, yes.
And the Lordship, the impin order, just learned single judgment,
Mm.
Lordship, that order was there, but I think it is not discussed anywhere about the
Mm.
continuity of the order passed in the other batches of writ petition, which is still continuing, my lord.
Yes.
That is not dealt with. We argue, that was discussed. And it is a part of the record,
Mm.
one of the annexure before the learned single judge. Lordship.
Yes.
And on topic, Lordship, the state government, as well as vice chairman, private respondent, never controverted the present appellate writ petitioner being the vice chairman.
They were not
Not controverted.
controverted in affidavit.
Yes, by filing counter, then what they says the Lordship, government.
That
in
the
their-
term has come to an end.
Yes,
That's the
that
argument,
is
but
the only
the
argument.
fact regarding the appellant having been elected as a vice chair.
It is not
is not
controverted
disputed.
anywhere.
Okay,
That is the thing, Lordship.
okay.
And even in Lordship, of course, it was not before a single judge, but in this memo of appeal, Lordship, but to satisfy the Honorable Court, I have enclosed the certificate of election, page 68, madam.
68. So, what is the temperature? Yes.
Yes. This is a certificate.
Why don't you read your pleadings and their response? Why don't you read your pleading in the writ petition regarding the appellant having been elected as the vice chairman and the response of the comment?
Yes, in the government counter, they have not dealt with it.
Where is your pleading, please?
Yes, that is that. Para number lordship. Yes, in
Page.
writ petition lordship, I have clearly stated.
Page,
Para number 10,
page, please, page.
page lordship, page 89,
Yes.
page 89.
Hmm.
Following the constitution of the Autonomous District Council in accordance with the provision of section 4
Hmm.
of the Manipur Hill Area District Council 1971. One Sono Shop from Rimbi Village of Ukhrul Autonomous District Council was elected as chairman subsequently. Present petitioner was also elected as vice chairman of Ukhrul Autonomous District Council Ukhrul, which can be substantiated from the letter that is so and so. Thereafter, the Ukhrul Autonomous District Council Ukhrul has started its function to carry out its public duties required and expected from such institution lordship. Now the government counter affidavit, lordship will find at page. Yes, page 159. 159.
Yes.
This para 10, which I have stated at
Mhm.
para number 4, page 162.
Hmm.
With reference to para 10 of the writ petition, the answering deponent has no comment to offer.
Hmm.
Also, the respondent number 4 in the counter affidavit lordship.
He is also a member, elected member.
He is the elected member.
Let's see what he says about
Yes.
this.
What he say in respect to this lordship, yes, I take the lordship to the affidavit of the. Yes.
Respond number 4,
Respondent number 4.
167.
Yes.
Yes, that is para 5,
One,
169, para 5.
yes,
Nothing to say.
nothing to say.
Hmm. Hmm.
This is the whole scenario, lordship. The only condition as on today, what it says, the lordship, that the ADC life having been expired, rule 9 will not come into play,
Hmm.
number 1. Number 2, what it says, the lordship, government has the discretionary power to appoint lordship. But under any law,
Hmm.
regard particularly to a democratic institutional lordship,
Hmm.
the government cannot have a discretionary power to appoint anyone, lordship.
Hmm.
Even forgetting every law lordship, they can ban some lordship. The person incumbent will continue till a new election is held and the
Hmm.
persons are appointed to their respective places lordship.
There is no
That is-
provision of appointing, say there are in cooperative societies, there are provision of appointing an administrator.
Yes,
There is no such provision here.
no.
Hmm.
that
Yes,
is- That is the thing, madam.
what do you have to say, sir? Can you unmute yourself?
Yes, my lord.
Yes, please.
My lord, the state government is taking this decision on the basis of the policy, my lord. See, in terms of the act and rule provided in the Manipur Hill tribals, my lord,
Hmm.
there is no provision for the after the expiry that the person who has been elected should be continued, my lord.
All right,
There-
so the same, I had the
there has
same, just hold on the same page. Answer the query. Does the state government have the power to appoint a caretaker chairman?
Yes, but because we have given this order in terms of the court's order, my lord. Court
Court's
has
order
given a
was,
liberty.
court's order, gentlemen, was that the status of the council shall continue. That means the council still is in vogue. The elected body continues. That's the court's order. You have not challenged that order anywhere. Rather, you have complied with it. Let's read your order of compliance of March 23. Let's read that.
Yes, my lord.
Read, please. That's at page 150.
For 158, my lord.
Yes, read, please.
My lord, I'll come to the this para 2, my lord. This was
Yes.
issued in compliance of the honorable courts of Manipur.
Just,
that
just,
is-
just let us see first, 4/11/22, the interim order.
Yes,
Where is that
Yes.
page number?
157.
150, interim order. For,
Interim order, lordship will find at the page number 69.
my lord, let me come to this writ petition number 613. That would be proper, my lord.
no, not
This
this,
does-
yes, 623. Where is the interim order
Yes.
dated? 4/11/22.
Yes, madam.
4/11/22.
411.
Yes, please.
411, right.
Let's see that. Page,
411, that interim order, Lordship, it is on NIC too, because in the final judgment, it is recorded.
yeah, all right, read from the final judgment.
Para number 4. Para number 4, Lordship, it is noted in the.
My lord,
Yes, it pays,
page
Lordship,
number 48, ma'am.
48,
Yes, ma'am.
not para number, not page number, not,
not 48.
yes. I take a Lordship to
Yes.
page
Hmm.
100 and, no. 118.
One moment.
Again reiterated in the other paragraph.
118 is their affidavit.
Pardon
My
me?
lord, this is regarding the judgment of the writ petition number 613, my lord.
Yes, 623, not 613.
There are 3 writ petitions, Lord.
Yes, 3 red petitions.
Yes.
Yes, that's what, my lord. I'm confined 613, 645, and 647, my lord.
Yes, yes, please.
This writ petitioners, my lord, they all are the chairman of the ADC, my
They
lord.
are the members of the ADC, elected body.
No, they are the chairman, my lord. They are the chairman. They are the chairman of the 6 ADC, my lord.
All right, okay, okay.
Chairman and member.
Chairman and members, all.
Yes.
Not only the chairman, but there
But
are
this-
6 petitioners in WPC
this is-
647, then in 623 also, there are 613, there are 6. So there are more than one persons, not only
Yes, ma'am.
chairpersons.
So in this allegation is that, my lord, in 613, the government is, they have not extended the term up to 6
Yes,
months,
so
my lord.
now, the
Now,
issue
in
is,
terms, in terms
what is
of
the-
the,
what is
rule,
the-
my lord.
Mr. AG, let's see the
Yes, ma'am.
operative portion of this order,
Yes, ma'am. Yes, my
which,
lord.
which you have complied with. Let's see. Come to
Page
page
number-
140,
Page
140,
141, my lord.
140 first.
Yes, it'll start from 141.
Please
141.
come
para
to page
17.
140, please come to 140.
140, my lord, yes.
Yes, the failure on part of the state government in holding election in time cannot be said to be a
Yes.
reasonable ground for supersession of the district councils, and therefore the order dated 3/11/2020, that was the order whereby you superseded the council, right?
Yes,
That has been
This-
quashed. That has
yes,
been quashed.
because this,
Then-
this order was issued, because we have, in terms of the rule, we have to be extended another 1 year, by law, after the expiry.
Yes.
So we have extended before the 1 year. That's what the court has said, it is bad in law and it has been set aside.
Whatever, Mr. AG, fact remains that your order whereby the council was superseded has been declared to be bad. No
Yes.
dispute, all right?
Because,
Then
yes,
read the further lines. On top of
Yes.
it may be
on
noted.
top of it, it may be noted that 27/11/2022, when the writ petition is being, this came up for consideration, this court passed an interim order directing the term of district council be extended till 14/4/12/2020,
Hmm.
and that necessary order should be issued accordingly. Instead of issuing any order extending the term till 4/12/2022, the interim order was issued superseding the district council, which is contrary to the interim order dated 27/11/2020, passed by this court. In other words, the
That
interim order.
27, just, Mr. AG, the order dated 27/11/20 conveys that the term of the district council shall be extended, right?
Yes,
Now come to para D of the operative portion of the order.
yes. Till such an order is issued by the state government, as mentioned in the direction.
See above.
the
Yes.
C, the C is the, my lord, after the opinion of the Hill Area Committee, Manipur
Hmm.
Legislative Assembly being duly received, the state government shall take a decision and issue an appropriate
Whether
order
decision has been taken?
No.
Whether
decision
decision has
is-
been taken?
regarding holding of the election, my lord, decision
Yes.
was taken. But
Then-
due to the sudden law and order situation, we cannot hold the election.
Whatever, whether the decision has been communicated anywhere, whether it has been notified?
Yes, my lord, that was notified, my lord, but today I cannot apprise, my lord. It was already notified. In another case, my lord, we
Mr.
have already
Devanand,
apprised.
Mr. Devanand, fact remains that till your decision is brought on record, the council continues to remain in force under the directions of the court
Yes,
that you can't dispute. So
Yes, ma'am.
the finding of the learned single judge in this order, which is under challenge, that the council is no longer in force, no longer functional, is contrary to the earlier order passed by single bench. And the present order, which is challenged here, does not take into account the order passed earlier by the Red Court in the same High Court.
No, my lord. The learned single judge took this count, my lord. My lord, let me take to the learned single judge order
Yes, please.
in
please
page
tell
number
me.
41.
Yes, please. Page 41.
Yes, my lord.
Yes. Let's see. Where is the writ number 613 referred to? What,
Yes, my lord.
what has been, what directions? What directions were issued? Whether that has
My
been
lord,
accounted for?
let me come for para 19, my lord.
19. Yes, please.
My lord, I'll read from para 18. my lord. That will be-
Yes, please. Yes, please. Sure.
Upon constitution of the new autonomous district council in accordance with the provision of section 4 of the act,
Yes.
Dr. Yaronsong Ango from Ringpui village was elected as chairman of the autonomous district council, Ukru, and the petitioner hearing was elected as the vice chairman. As per section 13 clause 1 of the act, the term of the office of the members shall be 5 years. Since the first election of the 6th ADC in the state of Manipur was held on 1/6/2015, term of the office of the members of all the ADC expired in the month of June 2020. After the expiry of the term of 5 years, the Hill Area Committee has recommended extension of term of office of all the members of 6 ADC for a period of 6 months. Accordingly, as per the provision of section 13 clause 1 of the act, the additional chief secretary T.N. Hill issued an order that 19/3/2020, whereby extending the term of the office of the member for a period of 6 months with effect from 1/6/2020. In the said order, it has been mentioned that election to the ADC shall be held in the intervening month of October and November 2020. Thereafter, Additional Chief Secretary T.N. Hill issued an order on 30/11/2020, appointing the Deputy Commissioner to exercise all powers and perform the duties conferred and upon the Council for smooth functioning of the administration of the ADC. 19. Agreed by the issuance of the order that 30/11/2020, a base of writ petition 613 came to be filed before this court. This court, by the order dated 2/3/2021, disposed of the writ petition with certain direction. The operative portion of the order as read as my lord. Para 17. For the reasons stated in above, writ petition being shown stands disposed of with the observation made here above. Why writ petition number 645 of 2020 and writ petition number 647 are allowed, and consequently impugn order dated 30/11/2020 is passed and set aside with the following direction. A. The state government, in particular, Additional Chief Secretary T.N. Hill Government of Manipur, shall write a letter to the Hill Area Committee, Manipur Legislative Assembly, seeking its opinion as to whether the term of district council be extended or not till the completion of the election, and the said letter shall be written within a week from the date of receipt of copy of this
All right,
judgment
just
order.
pause here for a moment, Mr. Devanand.
Yes, madam.
Whether this order, this direction has been complied with?
This order has been complied, my lord. We have to, and we filed the appeal also. Appeal is pending before the division bench, my lord.
Appeal
So
against?
for holding the election, my lord.
So there is no stay in that appeal, we presume? That's what the statement is made?
Yes, my lord, say is
Not
granted.
not holding the election. Para A. The Manipur
Yes, no.
Legislative Assembly is seeking its opinion as to whether the term of the
Because,
district council.
my lord, why we have not placed the district division bench or the appeal is that because we have already fixed the date for the holding the election. And subsequently, because of the law and order situation, we cannot hold the election. ma'am.
So the implication is, Mr. Devanand, till the
Yes,
elections are held, the council as it existed earlier has to continue. That is the intent of this order. And
My
if
lord,
that continues, the finding
the
that
issue,
the vice
the
chairman,
issue,
yes, please.
my lord, the issue in this case is that since the chairman who was acting as a caretaker in the
Yes,
Ukhrul
he
ADC,
resigned. He resigned.
he resigned in
So
2022.
does the state government have the power and authority to appoint any one of the members to be a caretaker chairman? When they rule,
lord-
because you have appointed him on the ground that he was the erstwhile member of the elected body, right?
My lord, what I want to say is that, my lord, after June 2022,
Yes.
particularly this vice chairman who is claiming that he should be the chairman, he never challenged the order issued by the government of 411, my lord, appointing the deputy commissioner as a caretaker, my lord.
Irrespective
My
of
lord,
that,
yes,
that
my lord.
order is, that order is no
Yes.
longer in force.
What I want to say is that, my lord, from June 2022 to till March, my lord, he was in silent, my lord.
Yeah,
He
that
was
doesn't
in
make any
silent.
difference.
Yes,
That-
my lord.
Does that make any difference? He knew that his peers had challenged that order. He very well knew that. Yes.
But my lord, coming to this writ petition number 632, 633 and 704, relying that, my lord. This
Yes.
was filed by the some other district council as well as the municipality council, my lord. And there was no stay order in this ADC, my lord.
Yes.
My lord. Let me take to the order pass in this 6-1.
Mr. AAG, first
Yes, ma'am.
tell us, please clarify the situation, this direction given at para number A, whether that has been complied with or not. Give a clear statement, page 56.
That is the earlier writ petition, my lord.
Writ
The earlier
petition number
petition.
613, 613.
Yes. What I want to say is that subsequently another writ petition, my lord. That is what I want to bring, my lord. Coming to
Whether
case
the
number one.
other writ, the subsequent writ petition, the order passed
No, it-
therein would nullify the
but it
orders
com-
passed by a coordinate bench.
No, my lord, I'm coming into to this present case regarding compliance of the writ petition number 935, 632, 633, 704 and 8880. my lord.
We'll come to that later, sir. First, answer our query. How have you complied with this direction at para number A? First, answer that query.
Subsequently, we have already issued the order, my lord.
Where's
My
the
lord,
order?
kindly
Let
come
us
to
see.
page num-
Read the order,
ki-
please.
ki- Kindly come to page number 143, my lord.
Just
Page number 143, my lord.
143. Read,
Yes,
please.
my lord. 17 May 2021. my lord.
Yes.
In supersession of the previous government order number so on dated 30/11/2020, and in consideration of the recommendation of the State Executive Committee, Relief and Disaster Management Department, Government of Manipur is pleased to appoint all the existing chairmen of the Autonomous District Council as a caretaker chairman. This is an interim measure till the election of the Autonomous District Councils are held, my lord.
Yes. So what is the
care-
indication in this order regarding
Yes.
continuance or otherwise of the term of the district council?
Yes,
What is the
this
indication?
was, my lord, this was again superseded, my lord.
All right, let's see.
My lord, let it come to page number 146, my lord.
Yes, please.
4 August 2022. my lord.
Mhm.
In pursuance of the cabinet decision dated 21/7/2022, the governor order dated 17 May 2021 is cancelled and caretaker chairman system under the autonomous district is discontinued with immediate effect. my lord.
Okay, okay. So what is the consequence?
Consequent, that's what, my lord. After this, only this person, my lord, this 147 is coming now. The 147, my lord, they are filed by bunch of writ petition. Out of this 5 writ petition,
Yes.
4 are belong to the Manipur Municipal Act, Municipal Corporations case, my lord.
Yes,
Only
please.
one is for the ADC, my lord.
Mm.
And this ADC's matter, which is writ petition number 632, my lord, if I'm not wrong, my lord.
Mm.
That was not, no interim was granted, my lord. By relying the municipality, my lord, where there, this writ petition was disposed, my lord. Let me come to the, my lord, page number 154, my lord.
Yes,
There are
please.
10. Considering both sides' argument of the party, it is made clear that this court, while admitting a writ petition, granted an order of interim stay, the operation of an interim order dated 23/8/2022 and 1/9/2021. This is not related with the case of the ADC, my lord. This
Yes.
two order is related with the municipalities, my lord.
Yes, yes.
Because municipality is under the Municipality Act and rules, my lord.
Mm.
Also, in other writ petition are continuing till that, and if the interim order will be
No,
continued
no,
till the
come
issuance.
to para 13. Come to para 13 of this order.
Yes, my lord.
Hmm.
Therefore, I am inclined to grant the interim order already granted in writ petition number this, and accordingly interim order 4/8/2020 writ petition number 6 are stayed, my lord.
Hmm. So the interim order was granted for the councils also.
Yes, my lord.
Hmm.
Therefore, I am inclined to pass the following order. The present writ petition are disposed of. The interim order granted by this court on 4/11/2022 and subsequently in order writ petition this by law should continue till the issuance of notification of election of ULBs and autonomous district council by.
Yes, so
So what is the wrong?
that
my
order
lord?
has been set at naught. That order
Yes,
of 4th August has been set at naught.
Set.
Okay?
Yes. So that means that the liberty has given to the government, my lord.
Hmm.
So since they in the
To act
terms
as
of the
per
rule-
law, not above the law. The law says, you see the situation which can be culled out from the various orders passed by the courts is that the term has not been discontinued by the government in terms of as per para A of the order passed in the earlier bunch of writ petitions. You are required to take a specific decision whether to continue or not. You have not taken a decision to discontinue, right? Meaning
Yes, ma'am.
thereby, the direct implication is that the council still continues. You have appointed one of the elected members as a caretaker chairman. What is the reason behind that? When the council had elected a person, which fact is not disputed by you in your pleadings, rather it is admitted, no comments. Specific pleading that this person was elected as a vice chairman. Why not appoint him? What is the difficulty?
But since the act and rule is not provided, my lord, after the expiry of the 1 year.
Oh, gentlemen, you are
But the
confused,
rule-
please. There is no order of discontinuing or curtailing the term of the ADC. You can't have the cake and eat it too. You don't hold elections and at the same time say that in spite of the order of the court, the term of the council is over. You can't say that.
No, my lord, my submission is that the
Yes.
person who has been now appointed as a caretaker, he also one of the elected members.
Yes,
the
all right.
ADC.
But the law says if you are treating him to be an elected member, then the law says that amongst the elected members, a vice chairman has a better position, better standing to act as a chairman.
No, it
That is what
doesn't
the
say.
law
my lord.
is. Yes.
No, it doesn't say.
Rule 9,
doesn't
already
say.
read rule 9.
This rule
Read
9
rule
will not be applied, my lord. Once the expiry has done,
Oh,
that rule 9 will be applicable.
Mr.
My
Devanand,
lord, yes, my lord.
how can you say that the term has expired in light of direction given at para A and para C?
Because that case, my lord, that in the writ petition, that writ petition was filed before the expiry of the term, my lord.
Now the order says till you declare the elections, the term will continue. You have not been able to get a stay in the revision bench. Is it correct? On
Yes,
that
my
order?
lord.
So then all right, you have to comply with that order. Plain and simple. Anything else to say? Who is
My
for
lord,
the
I'll
respondent number
file
4?
this thing, I'll submit in the detail in the physical matter. That will be.
All right,
proper.
come on Monday, Tuesday,
No, no.
Tuesday.
Yes, on Tuesday, my lord. we can
Yeah,
do
all
it.
right.
That's what
He
my lord,
wants to
yesterday,
come and address the court
yesterday I
physically.
was in Guwahati, my lord. I was not aware that the matter was listed.
28 is not holiday here, my lord. 28.
No, 28th is not a holiday.
The 28 we can have. it.
28th, all right.
May I please, my lord?
My lord,
Yes.
My lord, my lord,
no problem.
Yes,
my lord, I represent the respondent number 4,
yes.
the caveator, my lord.
All right, you
and-
address the court on 4th. We'll hear the matter
My
again
lord,
on 28th.
in-
28th.
In fact, my lord, as rightly pointed out by our land additional AG.
You want us to pass an
that,
order today itself? You want us to pass an order today itself, based on whatever has been argued?
Then
pass the order.
Then in that case, no, my lord, our humble submission is that in that case, if the matter is going to be taken up finally on.
We
then
don't know.
a-
We have
an
not, we
appropriate-
have never said that we are finally deciding the matter. We were about to pass an interim order. Additional Advocate General has prayed that he wants to address physically.
Yes, my lord, for passing any kind of interim order, my lord, that may kindly be passed on some other day, my lord.
All right.
Any
Matters were-
convenient date may kindly be fixed, my lord.
The matter was partly heard on the prayer for admission and interim relief. After addressing the court through VC for a significant period of time, learned Additional Advocate General Manipur submits that he would prefer to address the court physically by physical mode on the net after a short date. And he seeks a short accommodation on that ground list on 28th September.
Obliged.
All right.
Obliged.
Item number 25.
May it please, Your Lordship.
Yes.
Item number 25, 27, and 28 are analogous matters, my lord. And 25 and 28 I'm led by learned senior counsel, Mr. K. Chaudhary. Just here in the court, my lord. In the meantime, if I may kindly narrate my lord, the facts, my lord.
Very well.
My lord, this appeal, these appeals are against the common judgment and order dated 20.
Basically, issue of answer sheets,
Answer sheets, my lord.
answer keys.
Answer keys, my lord. So what had happened, my lord, the appellant before your lordship, she had appeared for the APSC 2018, my lord, CC examination.
Yes.
My lord, after the advertisement were issued, my lord, they all appeared for the preliminary examination. And the results were declared, the first results of the preliminary examination were declared on 13/03/2019. When the results were declared, my lords, as per the first answer key, 3,361 candidates were selected for appearing in the mains
Then
examination.
they revised the answer keys, added 400 more candidates.
Yes, exactly.
But you are still not there.
Exactly.
Even in the extended list. Yes.
My lord, what had happened, my lord, after the first answer
Now
key,
let Ms. Chaudhary is here.
Yes,
Yes.
may it please, Your Lordship.
Mm.
My lord, out of 60,275, in the initial result was declared, my lord, 3,361 were declared elected, I mean,
Yes.
selected. Then, my lord.
Not selected, shortlisted.
Sorry, shortlisted.
Mm.
My lord, normal procedure which APSC follows is first day, my lord, before declaration of the result.
They invite
No,
objections.
they upload the, my lord.
Upload answer key.
But in this case, they did it later on, my. Now, a hue and cry was raised, my lord. Not many objections came from different quarter. Then one of the suo motu undertook an exercise whereby they made eligible another 406 candidates.
Of revising the answer keys or
After,
whatever.
yes.
Yes.
Even, my lord, in this second revised answer key was also not free from error. Now, as far as we are concerned, my lord, there was an interim order whereby initially we were permitted to fill in our
Participate
forms.
for the
Then-
final
Then we are permitted to appear in the, my lord.
final
mains.
exams.
Yes,
Okay.
subject to outcome of the case.
Mm.
It so happened, my lord, we not only cleared the mains, we also were eligible for the viva voce, and we are two of us, my lord, appellant in this case and appellant in item number 28, my lord. We in fact qualified in the viva voce also, my lord. And in fact, seats were, my lord, reserved for us until the impugned judgment, which was rendered after almost 2 years, my lord. Now, my lord, the issue is, as far as APSC is concerned, they have made their position very clear. That since preliminary examination is in the nature of only, my lord, screening, and there are 2 layers of tests, that is main written test and viva voce is there.
Yes.
Therefore, my lord, the APSC did not object. APSC left it to the wisdom of the honorable court.
Object means what? Because what the candidates are asking is,
Issue is
you
something-
changing the result.
No, issue is something, my lord. We are basically seeking relief in the equitable relief, my lord.
Ms. Chaudhary,
Yes.
equitable relief, can it be restricted
No, I'm
to
coming.
a particular set of candidates
No.
who
No,
have approached the court?
Question is, my lord, when Lordship must have by now Lordship is aware of the factual aspect. There was a batch of 99 candidates who also, my lord, on account of wrong answer key, my lord, they could not have passed out, my lord. They could not have cleared the prelims. Now, their case came to light during when they undertook the exercise. When this aspect was brought to the notice of this honorable court, they were permitted to sit in the written examination. Out of that batch, my lord, 61 qualified for written. And out of 68, my lord, 8 qualified for, my lord, interview. And eventually, my lord, 4 qualified in all the tests.
What
So
has
they-
happened?
They were
Ultimately, they have been selected.
selected.
Even though as per the
Yes.
answer keys, they were not entered.
Yes. In their case also APSC stand was, in fact, I'll just place the stand of the APSC, my lord. And the affidavit of party. Page.
Thank you.
315, my lord.
Yes.
Please come to page 315, my lord, Roman 3, towards the bottom. There will not be any prejudice towards the results declared on 13th of March. Therefore, the 98 candidates out of 3361 candidates declared qualified to appear in CCE, a main exam whose marks came below cutoff mark due to revision of answer key, were not to be discarded and allowed to appear for CCE main.
They were actually victims of revision.
Yes.
But your case is not at par.
No, my lord. Our case, I'll project, my lord. I'll show, my lord, how prejudice has been caused to us. In other words, the list of 3361 candidates earlier declared to have qualified to appear in CC main examination, white dated, will remain intact. In deciding so, commission opined that these 98 candidates have already been declared to have qualified for the mains, and removal of these candidates and inclusion of 406 fresh candidates in one go will entail complete cancellation of the notification and require issue of a fresh notification containing the new results. Since there are two more stages to assess the merit and suitability of the candidates, commission decided to allow these candidates to be given a chance. So we stand on the same footing, my lord. In the sense, my lord, because of wrong answer key, we are also not within the cutoff mark.
But you were not earlier declared successful.
No, no, my lord.
Those were people who were earlier declared successful.
Lords will kindly assess our answers which we attempted and where marks were not given.
That is
That's
not the
what-
scope, Ms. Chaudhary.
No, I know, my lord. I
Vikesh
know the
Gupta.
limitations.
Vikesh Gupta.
No, that I know, my lord. But if black is said white, my lord, there certainly lots of can interfere. Now, page number. My question to the page 17, no? Yes. Please come to my lord, page number 17, my lord. 17, 18, no?
17.
18, my lord. For example, question number 93. Who was the founder of Pala dynasty? Now, these were the options, my lord. Brahmapala, Viradatta, Indrapala. Option marked by the petitioner in the OMR option A. As per first answer key option A, as per revised answer key grace, correct answer is option A. I was given grace mark. I should have got two. Kindly see, my lord.
No, grace marks were given to all candidates probably. Then
Yes. Yeah, all right.
those who had opted for A.
All right, but my lord, I have answered the correct answer. I was short by only 6 marks. I have answered, I'll show, my lord. Now kindly see, my lord, the appellant petitioner has been illegally deprived of 1 mark by allotting grace marks to the said question, although she had marked the correct answer. Appellant petitioner relies upon book A, Comprehensive History of Assam by Dr. So-and-so, head of the department. Reliance
What is the final decision taken by the APSC to delete this question?
No.
Then?
Instead of giving 2 marks for the correct answer, APSC gave me 1 grace mark. There are other questions also, my lord. This is an example, my lord. Then my lord will kindly come to page 20. Page 20, my lord.
But in any event, in the first evaluation also,
Yes.
if you had been given 2 marks, but still you did not qualify.
No, my lord, there are
That's the case of the 98 people.
No, my lord, there are 8 questions where I was not given marks. There are 8 questions. My lord, when the APSC stand is that preliminary is only by way of, my lord, screening process, and 2 layer of merit test is there. The stand which I have taken in respect of the 98 who otherwise was not qualified, but because of the wrong answer key, they were qualified. I think the same stand could have been taken in our case, my lord. And in fact, APSC had taken. And in fact, my lord, the learned amicus curiae who was appointed by the learned single judge, even learned amicus curiae has also, took the same stand, my lord. But since the aberration is very minuscule, my lord, therefore. it
Who was
can
the
be ignored.
amicus?
Mr. N. Datta, my lord.
Okay.
So, my lord, therefore, India, my lord, this is not a question of giving any relaxation. The learned single judge approached this case from the perspective of a relaxation. We are not seeking any relaxation, my lord. If the 8 questions which I attempted, if right answers were given, was there, my lord?
Okay, what is the position of the,
I can appreciate, my lord, supposing there is an objective type of question. Supposing I got 6, I think, no, I should have got 8. Their lordships will not sit in appeal over the, in judicial review. All that I am saying is, my lord, where the sun rises, I say it is rises in the east. Where is the scope? APSC says, no, it's not east-west, then also it will not do, my lord. So, and my lord,
Page 247.
247, my lord, if your lordships will kindly see. Now, the affidavit starts at 249. If your lordship would kindly come to page 256.
yes,
This was the affidavit filed by the APSC, my lord.
yes.
Kindly see WPC 3341, it was filed by the appellant. The petitioner claimed in the writ petition that in the general studies paper, serial question number 6693 in Indian history optional paper, question 8, 15, 44, 63, she had not been awarded a total of 10 marks for 6 questions, which she answered correctly as per the second answer key published by the commission. Thereafter, in terms of the direction of this honorable court, the answer keys relating to CC preliminary examination was re-verified through the paper setter domain expert, and review of the paper setter domain experts are as follows. Kindly see, my lord. Question number 66. Which of the following was the first Onkiya Nath written by Hankordev? According to the petitioner, correct answer is option B. Paper setter domain experts stick to option A, that is Patni Prasad. Then question number 93.
No reason.
And my lord, they have not given any reason, my lord.
No, that's all right, Mr.
Yes,
Chaudhary.
yes.
Question here is that if we accept your submission,
Yes.
then the answer to these questions have to be accepted as suggested by you. That would amount to a fresh revision of the answer
No, my
keys.
lord. I'll not call upon your lordships to do that
Then
exercise.
without that, how can we?
Let APSC do it, my lord.
But they've already done
No,
it.
they have done it wrongly, my lord. Apparently,
That-
they've done
that-
it.
Is that justiciable?
No.
Is that justiciable?
wrong. What I'm saying is, my lord, in an objective question, certainly not.
Then
But it's
this is an objective question only.
Sorry,
OMR.
in a subjective question, certainly, but it's an objective question, my lord.
Yes, so, but they have got it tested through a domain expert.
No, domain experts are also wrong, my lord. Even
Oh,
themselves.
Is that the scope of a judicial review? Tell us.
No, my lord, it's an extreme
Come to,
case.
come straight to Vikesh Gupta.
No, my
Whether
lord,
the court can sit in appeal.
no, I'm not calling upon your lordships to sit in appeal over the evaluation. What I'm
Then-
trying to say is, my lord, when there is an error apparent on the face of the records, which can be.
Who is to decide that? Who is to decide
No,
that?
my lord, if we are relying on certain authorities,
Hmm.
my lord, if they are to discard our stand, our suggestion, they have to give some reasons, my lord, that according to this author, according to so-and-so author, according to so-and-so authority, the answer is this. They simply say, then my lord, kindly see second question number 93. Who was the founder of Pala dynasty? According to petitioner, correct answer is option A. Commission already decided that since question was not clear and specific, mark given was on pro rata basis 1 mark. Then Indian history optional paper, earliest tax of Aryan society was, according to petitioner, correct answer is option B. Paper setter stick to his view of option A, Vishti. Now please come to page 91 for a moment, my lord. Please come to my lord, para 140, my contention, my lord. Sri so-and-so, though on behalf of those two petitioners placed certain book relating to answers given by those petitioners with regard to the questions involved in the matter, but at the same time, APSC has also placed before the court the name of the relevant books on the basis of which his domain expert has prepared and the correct answer. This is wrong, my lord. Does it follow from page 256 that the APSC has referred to any domain expert's view or they have referred to any books?
Two 56 says
Yeah.
domain expert.
Then my lord will kindly come to page 140.
Just let's see 256. It doesn't it say paper setter / domain expert?
Huh.
Stick to his option,
Option.
Patni.
My lord, they have to give a reason. We are saying, you are saying so, we are saying based on this authority, this should be the correct answer. Then they must come up with some explanation, my lord. End of the day, we are students, my lord. Please come to page 140, my lord. Huh. Especially when this second answer key was also not faulty, was faulty, my lord. 141, my lord, sorry, 141, no? Huh? 140.
141.
No, kuntu asle, is a page, yes, para 140, yes, the hello. Then my lord will kindly come to page 256, question number 15. Physician Zivaka served with which king? According to petitioner, correct answer is both option A and B. Paper setter, domain expert commented that physician Zivaka served both under so and so and so and so. Hence, grace
So
mark
there
should
were
have
two answers. So that had to be a grace mark. That decision is absolutely
been- No,
justified.
everybody else got 2 marks. I got grace mark.
When we challenge.
Which everybody else.
The other, my lord, the candidates who attempted that answer.
So,
As per the answer.
but you didn't offer any answer or what?
No, I have heard.
What are
According to correct answer is both A and B. I said both A and B.
you didn't fill any answer. If you had filled either A and B, A or B, they would have marked you. You chose not to answer.
No, my lord, I said both are correct.
We understand,
Huh.
but you say that others have been given two.
Huh.
Two on what? On what answer?
For this.
So
for
if there are
attempting
two
this
correct
question-
answers, the candidate who marks whichever of the answers get the mark.
Yes.
So that's what has happened.
Okay. Malad, there are 6 other questions. Question number 44. Largest administrative division in Vijayanagar Empire was, according to the petitioner, the correct option is both A and B. In view of the comment received from papers and website, both were correct. Commission has already awarded grace marks on pro rata basis. Then, my lord, which battle did Babur fight against the Afghans? According to petitioner, correct answer is D. Paper setter dominator stick to the revised option A, that is Panipat. Thus it is, how everybody knows it's not correct, my lord. Well, this is how I was deprived of 10 marks. I was short by only 6.
Yes. Panipat ki ladai. There now you are in sticky ground.
Page 318.
Oh, between whom did the Panipat battle take place? Tell us.
Page 318, Lordship.
318.
318. Lordship, this is incorporated in our affidavit, Lordship, was filed in purchase of this order of this honorable court. The affidavit starts from page 301.
Yes.
And we have given the details of the justification of awarding marks. Lordship, suppose page 301, we have made it in tabular form. The Shalini Khan is the appellant.
Oh, tell us, simple. Now the competence of your expert is under question. Between whom was the Panipat battle fought?
Let me come, Lordship. The claim of the petitioner is that she obtained 254 mark and in 6 question, although she has chosen the correct answer, she was not awarded mark. If she would have been awarded 6 into 2 is 12 mark, she would get 266 mark, which is more than the qualified mark, is 261. It as per question of 66, which is the following was the first written by Shankar. There are 4 options, and according to petitioner Lordship, the B was the answer. But as per our first answer key, it was A, and after revision, it was found A.
Yes.
So, and the authority which we have realized that Asomia Sahitya Samikhatmok Itibita by one of the greatest scholar, Dr. Chetyendranath Sharma.
Yes.
And second, Lordship, who was founder of Pala dynasty. The petitioner's answer is A, Lordship. And first answer key was A, Lordship.
Yes.
But in revision, it was found wrong, Lordship. That's why the grace mark on pro rata basis was awarded to all petitioners.
All.
Even-
Okay.
Even before, during the re-verification, she was also benefited. Next question, Lordship, page 319, Lordship. The earliest text of Aryan society was, the petitioner's answer was B, Lordship.
Yes.
As per first answer key was B, but as per revised answer key was A. That in view of, so Lordship and the APSC authority is the Penguin History of Early India by Romila Thakur.
Yes.
Next, Lordship, physician Zivaka served in which king? Lordship, his option A, our first answer key B, and as per revised answer key, it was also B.
Hmm.
So petitioner may be awarded mark against so and so. Grace mark
Why,
against so-
why, if her answer is wrong,
Lordship,
why are you awarding her grace marks because of,
So it is the petitioner is entitled here, Lordship.
why? You say that her answer is wrong.
Yes, no, Lordship, as per petitioner answer key B, and our first answer key or revised answer key also.
So
Oh,
that's what
Lordship,
we are
yeah.
asking. Then why you are giving her grace marks?
No,
There is
no,
something suspicious in your conduct then.
No, Lordship, it is the last Lordship column that it was done as per the order of this honorable court. That's Lordship, see, the last but one column, view of the APSC after court order on the basis of domain expert view. We have sent the answer key twice to the expert Lordship. First so moto, then second as per
Direction of the court.
Lordship.
Okay.
Court. That's why.
Why? What is the reason for awarding grace mark? If her answer is wrong, as per you,
Lordship, it is Lordship, the awarding guest mark is a system evolved by Honorable Supreme Court Lordship.
oh, we understand.
2007,
But
Lordship.
there has to be a justification behind. Is it awarded to her only or to all the candidates?
No, Lordship, candidate Lordship. It is when our answer is wrong or ambiguous Lordship, we are giving that.
You are deleting that question and awarding all or not.
All Lordship.
Where is that reflection?
Lordship, next question I will come on to it.
Yes.
See, the largest administrative division in the Vijayanagar Empire was, as per his answer is B, and as per first answer key was also B,
Hmm.
but during revision, it was decided to given grace mark and it was
Why?
given grace.
Why? If her answer is, even as per your revised answer key, it is B, then why you give her grace
No, no.
marks? You give her 2 marks.
In the revision, Lordship, first revision, it was not found as a B, Lordship. That's why grace mark was given.
It was not found.
Lordship, in a first model answer key, as per our model answer key was
Hmm.
B. But when revised Lordship,
Yes.
so motor revision, it was found that it was not B.
Hmm.
That's why guest mark was given, Lordship.
Hmm.
So petitioner is not entitled to any additional mark. Already that guest mark was given, Lordship, to here,
Hmm.
Lordship.
Hmm.
Last, Lordship, which battle did Babur fight against the Afghans?
Hmm.
As per his petitioner's answer is D, our first answer key was also D, but in our first revisional answer key, it was found A, and even after the court order, it was found A, Lordship,
Hmm. Hmm.
the Panipat, Lordship.
This is palpably wrong answer.
Lordship, Indian history of second edition of civil service examination, K. Krishna Reddy, our expert relied.
This is palpably wrong, but one doesn't make any difference.
Lordship, kindly come to the note, Lordship.
Hmm.
The mark of the petitioner in CCP 2018 is 254,
Hmm.
which has been enhanced to 258 after show motor verification.
Hmm.
Even if she is awarded guest mark on pro rata basis, or she is awarded full mark 2 against the question number 15, she cannot score the minimum.
15 and assuming 63 also.
No,
Then also she doesn't get the full
you get the
marks.
minimum of it. And
Chaudhary, there is hardly any scope for interference.
Also will give me
You want-
5 minutes time, my lord. Please come to page 16 of the writ petition. now.
Yes.
We'll move it on, huh?
What is the status of the selection process?
No, my lord,
Already there-
otherwise, my lord, appointments have been made because the judgment was delayed by more than 2 years, my lord. Therefore, my lord, there was a stay order.
Hmm.
In respect of 6 posts, there was
Okay.
the interim order.
All right.
Yes. Please come to page 16, my lord,
16 at page number.
of the MMO of appeal, my lord.
Hmm.
Now, what I have shown was their affidavit. This is how we answered. Uh, Etu. Etu. Sorry, page 21, my lord. Question number 15, physician Jibika served which king?
Hmm.
These are the options, Ajit Sora, Bimbisara, so and so, so and so. Option marked by the petitioner is option A. As per the first answer key, option B. As per the revised answer key, option B. My lord, those whosoever has, I mean,
Mark
exercised.
A or B.
Ah.
Both they have been given 2 marks. That's right.
B,
Uh,
B got 2 marks.
Hmm.
Correct answer is both A and B.
But I
Hmm.
granted grace mark.
I was granted grace mark. Why, my lord?
So we are saying that assuming you get 2 for this and 2 for Panipat, then what happens?
I'm coming. There are others. Then my lord will kindly
That's
come
too
to.
much of a factual exploration, Mr. Chaudhary, in this exercise.
No, my lord, only 6 marks, my lord.
Only, even if it is only one, what difference does it make?
Page
What is the
20
scope? Tell us first.
No, my lord, I know the limitation of your lordships, my lord. Here is a case, I would say, my lord, even on the ground, only on the ground of equity, my lord, the learned single judge should have, my lord, because, my lord, APSC never objected to our prayer.
No, no,
Of
they are
course, I'm
not
not
objecting
saying-
means what?
I'm not saying merely because there was an unanimity, therefore court is not bound to give a judgment on that. That's not my argument either. But then, my lord, fact of the matter is, because the APSC's principal stand was, this preliminary examination is only, my lord, in the nature of screening.
Whether even in a preliminary examination, this kind of a lenient approach can be done.
No, my lord.
Show us
In
that on the askance,
in exceptional
we can
circum-
change the
In
results.
exceptional circumstances, my lord.
Show us one judgment.
Now, my lord, the APSC, my learned friend is relying on their part of the thing. I'll show, my lord, why I'm entitled to 6 marks.
Mm.
I'll just show from the very beginning. Please come to page 16. Which of the following was the first Ankiya Nath written by Shankardeva?
Hmm.
Now, these are the options. Option marked by the petitioner is option B. As for the first answer key, the option A. As per the revised answer key, option A. Correct answer is B. So, my lord, why it should be given not
No,
full
your
marks?
case is correct answer is B. They don't accept your case. They say that correct answer is option A.
Now I relies upon the book
That is going,
Northeast India People's
Mr. Chaudhary.
History Culture published by NCERT.
that can't be done. That can't be done. There was one judgment wherein we were called upon to answer the question, what is Gulabo famous for?
Hmm.
Right?
Gulabo.
Yeah, that was the dancer who danced in the Asiad. So we took that view, but that view was reversed.
By Supreme Court.
So that's not the scope,
Anyway.
basically.
Then, my lord, relies upon Assam Yearbook 15, relies upon the book Asamiya Sahitya, so and so, by Satyendra Nath Sharma. Then similarly, my lord, question number 93. Then similarly, my lord, question number 8. Then 15. Then question number 44. Then question number 63. So, my lord, if we add up to this, it's I'm getting additional 12 marks. Whereas they have given me only 5 na ki baat hai na?
The second answer was also not corrected.
And my lord, this second answer key, which is there, they're relying on, that itself is not free from error.
Who goes into that correctness or otherwise of that answer key?
But it has turned out. It has turned out that even
No,
second
from
answer
what-
key is
on
wrong.
your saying, Mr. Chaudhary, the court doesn't grant its certification to that submission that the second answer key is not correct. Whether it can go.
No, my
to
lord,
that.
I'll place from the minutes of their APSC, my lord, only.
Let's see that from that
Where they
already.
have taken that view, my lord.
Let's see.
Yes.
Therefrom. That page number.
After court had ordered.
Yes. My lord will kindly come to page 287. 287, my lord.
Yes. Yes.
The PCE APSC apprised that the commission had uploaded the answer key of the subject and also the homework sheets of each and every candidate of the combined competitive preliminary examination. Although utmost care was taken for ensuring accuracy, some genuine and inadvertent discrepancies in the answer keys were detected. Answer keys were therefore once again re-verified in consultation with the domain expert, and accordingly corrected answer keys were entered in the system, which resulted in some more candidates being found to have qualified to appear in the combined competitive main examination. This subject was just so and so. And please turn over to the next page, my lord. 288.
Yes.
Since after feeding the correct answer key into the system, it was found that 406 more candidates would qualify. On the basis of the earlier cutoff mark, it was decided to declare 406 candidates qualified for appearing in mains. there will not be any prejudice towards the results declared on 13 March. Therefore, 98 candidates out of 3361 candidates declared qualified to appear in the main whose marks came below the cutoff mark due to revision of answer key were not to be discarded and allowed to appear in CC mains. In other words, the list of 3361 candidates earlier declared to have qualified to appear in CC mains will remain intact. In deciding so, the commission opined that these 98 candidates have already been declared to have qualified for the mains, and removal of these candidates and inclusion of 406 fresh candidate in one go will entail complete cancellation of the notification and require issue of a fresh notification containing new results. Since there are two more stages to assess the merit and suitability of the candidates, the commission decided to allow this 98 to be given a chance. Then my lord will kindly come to page 290.
Yes.
The second, third subpara, the commission discussed the matter and observed that out of the 98 candidates, 68 appeared in CC main, and out of 68, 4 candidates, that is so-and-so, 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 could make it to the final selection list, and in pursuance of the order dated 22/12/20 of the Honorable High Court, withheld their recommendation to the government. Commission is now of the considered opinion that as CC preliminary examination is a screening and they could not clear it by whisker, and these 4 candidates by virtue of their own merit could successfully clear CC main examination viva voce, both of those marks are to be taken into consideration in the final selection. Hence, the commission fully stood by their recommendation as justified. With regard to the petitioners, my lord, the commission opined that Honorable Court in the interim order allowed both the petitioners to appear in the CC, and they cleared both the CC and viva voce by securing position in the final select list by virtue of their own merit. As such, the commission in respect of this to be done, leave the matter to be decided by the Honorable High Court. Hence, the commission have nothing to object to any decision taken by the Honorable Court by considering the fact that both the writ petitioners have qualified for recommendation by commission on assessment of the respective merit, that is an interview. So this is the view of the.
What is the interim order which was passed? Let us see.
Yes, interim order, my lord, we are allowed to participate in the.
What is the wording of the interim order?
Interim order to quote. Huh? That is huh? One second, my lord.
That must be clarified that without creating any lien.
Final results declared with right notification. One second, my lord.
So there are 2 appeals or more.
There are 3 appeals, my lord. One amongst the 4, and the 2 appellants are, my lord.
One amongst those 4 of from 98.
98 batch.
That has become infructuous then.
No, my lord, the item number 2, item number 26. I think,
But for them, the commission itself has taken a decision
no,
to stand by their recommendation. You just now read it.
No.
my lord, I'll just clarify.
No, APSC stand was, my lord, that they are not opposing and they should be considered basically.
27, my lord, I'm appearing.
No, please read that minutes you read earlier.
Yes, page 290.
Yes.
The commission is now of the considered opinion that as CC preliminary examine is a screening test and they could not clear it by whisker, and these 4 candidates by virtue of their own merit could successfully clear both whose marks are taken into consideration in final selection. Hence, commission fully stood by their recommendation as justified.
So they have been recommended by the commission. Where's the question of court's interference in this?
No. My lord, in fact, sir, I'll just address on 27, I'm appearing, my lord.
Yes.
What had happened, my lord, the case.
27, what is the name of the candidate?
Shashwati Das, my lord. Item number 27, my lord.
4 candidates, Shashwati Das, yes.
Shashwati Das. Well, the case of this appellant is in fact more unfortunate than the rest of the other 2, my lord. What had happened, my lord, I appeared in the CC
In
preliminary.
the first answer key you were selected.
I qualified. Thereafter, I appeared in mains.
Yes.
Thereafter, I appeared for the viva voce. Till appearing in the viva voce, I was not aware, or in fact, none of the other candidates were aware that I fell into those 98 candidates. It was only upon the honorable single judge. He inquired with the APSC, asking them that if you apply the second answer key, you have selected 406 additional candidates, but on application of the second answer key, some candidates from the earlier list
would be ousted.
go out.
Yes.
which the APSC themselves said that it will be without prejudice to the first order. Now, on that order, my lords, they gave a list of those candidates. My lord, I never got an opportunity to either object or either say anything because I was not even aware, my lords. It was only after I passed my Viva, my lords.
Question here is, they have been selected, they have been recommended. Then what is the problem?
Yes, because the honorable single judge
Acha,
passed an
withheld their recommendations.
passed an interim order saying.
So there are four people,
Four people.
all four of them are before the court.
Only one today, my lords, and other rest are my lords of the filing.
Appeals are still not here, not before the court.
Well, we never got a chance, my lord. We never knew.
Okay.
So my lord, more or less, my lord, both the groups stand in the same.
No,
footing,
no,
my
they don't stand in the same footing, sir. They don't stand in the same footing.
No, my lord, if there to be, my lord, of course, my lord, I'm not making any.
Their case
interest-
is condemned unheard. Their case is
No,
condemned unheard.
Eventually, my lord, we represented them before the learned single judge. Learned single judge passed an order.
Commission, if it was to house them as the 98 candidates who did not make it after the revised candidate, they would be persons who are condemned unheard, basically. So their category is different. These candidates, two appellants, there's a little difference in their case.
But end of the day, my lord, it's a whisker by somebody by 1 mark, somebody by 2 marks.
There may be thousands of such candidates. How many appeared in total? What was the total number of people?
60,000.
So 60,000, you would find thousands more who are within that six gap, 6 marks gap.
At least, my lord, nobody came before the court.
That's not an issue,
There
sir.
were 21 writ petitions filed, my lord. Out of them, 9 they themselves cleared. Then, my lord, remained 12. Out of that remaining 12,
9 cleared means in the 400. They must have come in
in
400.
the second round.
Yes.
Then, my lord, I'm relying on a judgment, my lord. Yes.
What judgment?
My lord, it's 2018, 2 SCC 357, my lord.
What is that?
Authored by Honorable Justice Lokul, my lord.
Basically on the answer key aspect, my lord.
They have devised the middle way. They look prejudice to the government.
Lordship, those candidates, lordship, were not within that 406 lordship. That those were allowed by the court among 21 lordship who came before the high court. And
I
as
never said, no, nine cleared by themselves.
Yes.
I never said that 9 includes the 4. Judgment of Dilan. My lord will, it starts at page 357. Please come to page 369.
Come
my
to the first head note
30.1,
itself.
para
Mr. Chaudhary, come to the first head note.
What a mess. It was.
Thank you.
Scope of judicial review, principles summarized,
Yes.
emphasize that sympathy or compassion do not play any role in matter of directing or not directing revelation.
Kindly come to 30.1 para, my lord.
Yes.
If a statute, rule or regulation governing an examination permits reevaluation of an answer sheet or scrutiny of an answer sheet as a matter of right, then authority conducting the examination may permit it. If a statute, rule or regulation governing an examination does not permit reevaluation or scrutiny of answer sheet as distinct from prohibiting it, then the court may permit reevaluation or scrutiny only if it is demonstrated very clearly without any inferential process of reasoning or by process of rationalization, and only in rare and exceptional cases that material error has been committed. Then, my lord, 30.3.
These are all against your own arguments.
No, no.
30.3 is squarely against what you are
Now,
arguing.
para 35, my lord.
First read para 30.3, please.
Yes.
That is totally against the principle you are trying to.
So, my lord,
project
we are
this
not
to the court.
trying to improve our case by any process of rationalization or my lord.
Please read
inference.
30.3, sir.
Yes. Court should not at all reevaluate or scrutinize the answer sheets of a candidate. It has no expertise in the matter, and academic matters are best left to the academics. Yeah, this is a general principle, but there are exceptions to it, my lord. Please come to para 35.
Yes.
Having weighed the options before us, we are of the opinion that middle path is perhaps the best path to take under the circumstances of the case. Middle path is to declare the third set of results, since board has undertaken a massive exercise under direction of the High Court and yet protected those candidates who may now be declared unsuccessful, but are working as trained graduate teacher as a result of the first or the second declaration of result. It is also possible that consequent upon the third declaration of result, some new candidate might get selected, and should that happen, they will need to be accommodated since they were erroneously not selected on an earlier occasion.
This takes care of the 400 people.
My lord.
This takes care of the 400 people who have come in, and the earlier part takes care of 98.
No, my lord.
So 98 and 400 position is different. These two candidates' position is
No,
different.
my lord.
If you can
Now,
convince,
now.
we can
things-
give you time to convince us on this, but scope is not there, Mr. Chaudhary.
No, well, I'm aware, my lord, scope is extremely limited. But then, my lord, there is always a way out to, my lord.
For what purpose should we look
No,
the
let
way?
them-
There is no need, because they have got the number of candidates. Why do we need a way out?
No, my lord. they
There is
have
no pressing
selected
need to
us.
fill the post.
They have selected us.
They have not selected you.
Yes.
No, they have simply said that, yes, you have cleared, but if you have not cleared the first threshold, the first hurdle, how can you be evaluated
No.
on the
No,
later?
my lord.
later
In
matter?
that case, how can your lordship make a distinction between the four and these two, my lord? The four or two are the same, my lord.
No, no.
Somebody was,
The four were selected by a stroke of bad luck. They got deselected. It's not your case.
no, my lord.
You
If-
don't
if-
care.
if
In
the
any
answer-
event,
no,
Mr.
that-
Chaudhary,
That is
in
where the
any
answer
event,
lies.
you
If the
don't,
answer would
no,
have
no.
been correct, they would not have been selected.
No, question here is, by no stretch of imagination, your evaluation can take you to 261.
Hmm.
So there is no question of you coming into the picture.
No, my lord.
For that matter, there may be thousands of more candidates.
I can only show that I have attempted the correct answer. The basis of saying so is so and so. Now, it is
That is
for
not-
them to take a call.
That is not subject matter of judicial review. That is well settled,
My
absolutely.
lord, let some
You have
expert,
Try your luck, Mr. Chaudhary.
no, my lord, let some independent
very-
expert, my lord. Have a look at it, my lord.
Not this.
I am saying so because, my lord, these are all students, my lord.
We
The
understand.
learned single just should have dismissed the petition then only.
Yeah,
After
there
2
you
years,
are
it
right.
has been done, my lord.
There you are right. There we agree. There we absolutely agree with
And we
you.
were
That
kept
this
on hanging for 2 years.
2 years. That's right. That's one issue.
Then, my lord,
Some-
we'd have known our fate 2 years.
Somebody
back.
may have become overage. Somebody may not have attempted. What do you
Yes.
say to this?
28 becomes.
That's something-
28 is already overage now.
And my
Really
lord,
a
now we
compelling
are
reason.
28, we are now already overaged, my lord.
Appellant item number.
Who?
I am appellant number 2.
She's overage.
Yes. So therefore, I was humbly submitting, my lord. Let APSC have a look into it, my lord.
You
Do some
take
independent.
your instructions
Ah.
on these writ appeals.
Hmm.
Get back to us on this aspect.
127.
What is their fault?
Hmm.
As a matter of fact, they should have been non-suited then and there.
Hmm.
Then they would not have to face this agony. Have you advised same post in the intervening period? Has there been a fresh advertisement?
Lordship,
But those posts were not advertised, my lord. Those
No.
were,
Those were kept
we were
reserved.
selected against.
No, not these 6 posts.
No.
The very same post, whether they have been pre-advertised.
No.
The same post, but there were subsequent advertisements by the CC.
CC is.
CC subsequent has
Yes,
taken
yes,
place.
second.
You did not apply, obviously.
The 27 I applied, my lord.
27 applied. What happened?
But she again cleared the prelims, she cleared the mains also, awaiting the results.
Okay, so her case is little different, yes.
So let them have the instruction, my lord.
Get your instructions on this aspect. That they have been kept hanging for 2 years for no fault of theirs. If their fate had been decided, of course, that is again not for the APSC to answer, but whether a sympathetic view can be taken
Yes.
in the backdrop of this circumstance. इसमें लिखिए, issue notice. So and so, dear. Mr. K. Chaudhary, senior advocate representing the appellants, urges that the writ petitions were filed on behalf of the appellants in the year 2019, questioning the validity of the answer key issued by the answer key and the revised answer key issued by the APSC. Full stop. The petitioners were granted interim protection and a conditional permission to appear in the final examination. Full stop. Appellants, both have cleared.
Yes.
the appellants have cleared the final examination as well as viva voce, and thus, they are now entitled to be appointed against the posts for which they sought selection. However, the writ petition which was heard finally, writ petitions which were heard finally on 4/9/2021 came to be rejected on 21 by judgment dated 21/8/2023. And in the meantime, the appellant Girbani Deka has become overaged and cannot apply for a fresh selection. It is further submitted that 98 other candidates who were shown to be selected in the first answer key, were ousted in the revised answer key issued by the APSC, but they have been considered they have been allowed to attempt the final examination by the APSC on its own. It is thus submitted that the appellants are also entitled to equitable relief in this matter. And counsel issue notice and counsel representing the APSC shall take instructions on these submissions advanced by the appellant's counsel.
The interim order which is holding the field, that will continue till the instruction is obtained. That is, the post will not be advertised.
The posts in question shall not be filled in the meantime, till the next date of listing.
My lord, the lordship may not add that overage, my lord. I'll take instructions. My
Card
calculation may not be
VJ.
overage.
Would the appellants herein, would face the risk of crossing the upper age limit for the selections? Change, re-notify on 18th October? 18th.
Deeply obliged.
My lord, could it be 2 days earlier, my lord? 18th, I will not be there.
16th October. Then let it go in November. probably.
November.
6th November.
Yes.
Item number 26.
Against an innocuous order of the single bench, nothing has been decided.
Yes,
Why?
my lord, but an interim order is passed, my lord. Then, my lord, the petition will be infructuous. Already the earlier petition has become infructuous because during the pendency of the petition, they have passed the order. Here, my lord, the petitioner is the lowest bidder, my lord, 18% below. For a silly reason, my lord, his tender is rejected. Your lordship may
Read the order, please.
101, my lord, page 101. It's a question of interpretation, my lord, that a letter is written, my lord, that annexure VA not submitted by one partner of partnership firm, Messrs. Latala so and so.
Yes.
Then next day they have replied, my lord, that with reference to your mail dated so and so, we are sure that we have submitted annexure VA duly signed by the power of attorney holder, so and so, power of attorney annexed with the tender documents for your reference. Thereafter, your lordship, see what is that VA, form VA? Page 103, my lord. Right side, it is my lord, annexure VA, that this certificate is to be given by attorney, authorized signatory of each member of partnership firm of joint venture, so and so, Hindu family venture. So he has written, my lord, that who is a partner, attorney, authorized signatory of Messrs. So and so. So first, my lord, it is my lord attorney. So this person is the attorney holder because the family.
All right, madam, but
my lord.
for an infrastructure project, we can't pass an order of stay.
It is, my lord, that
Section
only
20.
supply of stone, my lord, machine crush stone supply.
It doesn't matter, the purpose of the construction is
But, my lord,
railway track.
otherwise illegality will be done, my lord.
But let the
Lordship
writ
will
petition be
kindly
decided
direct me,
fine.
my lord.
We will not pass a
Yes,
stay.
your-
Sorry.
You will kindly see, my lord, that page 104, chapter 12 forms.
Yes.
Here also, my lord, that.
Who is
documents
appearing
we
for the
submitted with
railways?
The tender,
You're appearing.
the documents.
What is
to be
the
Submitted.
date for opening the tender?
Lordship already opening LOAs also issued.
LOA has been issued.
LOA is
Then what
issued,
can be done?
That's why,
LOA
my lord,
issued,
during
lordship,
pendency, my
and-
lord, because
and
the
lordship,
transaction
the
has misinterpreted the
Tendering
clause.
authority has done, lordship.
Ek minute, Malad Singh just has misinterpreted the clause. The attorney holder can, my lord, attorney holder can submit the form. He has signed it, but what is the necessary matter? When it is specifically telling, my lord, a minute. Page 105, your lordship, kindly see, documents to be submitted with the tender. Following documents are required to be submitted along with the tender by the tenderers for.
Where is the clause
consideration
10A?
date. Clause
11A.
5. Clause
My lord,
5, my lord.
kindly
Certificate to be given by
11 lordship.
attorney.
That is the
Annexure
11,
5A.
Wait, yes.
that is the 11 lordship. It is part of the tender document lordship.
Hmm,
It is a appendix 1 of tender notice lordship.
hmm.
Then my lord may come to again lordship, page 19 lordship. Page 19, it is a lordship instructions to the tenderers lordship.
Hmm.
My lord may finally come to clause 6 lordship.
Each member of partnership.
Each member of partnership, clause 6. Again lordship, it was reiterated in the regulation and guidelines to the tenderer lordship.
Hmm,
That was also in the lordship, page 30, in the third lordship, horizontal column lordship, page 30 lordship. It was also by the 5.2 lordship.
Already, let
So, my lord-
it complete. Yes.
So, my lord, in that clause, page 117, my lord,
Hmm.
there it is not specifically, my lord, but that the power of attorney holder cannot sign. And if it that is so, they being the lowest standard, my lord.
There are instructions to be done.
only one sign, my lord. Only one sign, they should have called him because he is the lowest bidder, he is of 18% below. And the tender given is to my lord 5% only.
Even
Yes,
lordship,
my
there
lord,
are
that
13
5% below.
participants is there lordship. Out of 13 lordship, 4 are successful in the lordship, first round lordship. Other 9 are rejected lordship, technical lordship. It's a infrastructure project regarding lordship.
Infrastructure is only, my lord, you
By
have
the
to
cover job,
read, my lord, yes.
is a infrastructure project lordship.
Supplies to,
regarding
my lord.
regarding lordship, the stone in between the railway line lordship. It's a lordship new construction of the railway line. lordship.
Aggregate, which is, yes.
Lordship,
That's right.
lordship,
Hmm.
lordship.
I mean, it should not be that court can dispose of the matter, my lord, before the vacation also can matter.
Make a
No, my
request to
lord,
the
no,
single
no, no.
bench. We'll give you liberty to request the single bench. We'll observe that you make a request to the single bench to dispose of writ petition earlier.
Because what is understand, Rana Singh has understand, my lord, that power of attorney will not do. But the clauses said, my lord, the power of attorney will do. Whether it is a question of interpretation.
Yes.
He misinterpreted, that's why I have filed appeal.
Hmm,
Because
okay.
he has misinterpreted.
Very well.
My lord, the power of attorney here, my lord, 2-3 documents are there, which suppose, my lord, in the form itself, it is written, my lord, the power of attorney.
Hmm.
Power of attorney, all can understand. The certificate is to be given by attorney. Attorney
Yes,
is power of attorney. So how he can deny it and did not pass an
Yes,
interim
yes.
order?
Very well.
And earlier, my lord, writ petition has become infructuous because during the pendency of the writ petition, my lord, they have issued a my lord acceptance letter. Number one. Number two, I have to make parties to them. Earlier, they were because no acceptance letter was issued, so they were not party. So I have to file a petition. Earlier, writ petition has become infructuous
Yes.
because of not passing an interim order.
Hmm.
Here, my lord, if your lordship is not passing an interim order, the whole writ petition will be infructuous.
That's the risk
Because
when you
next
face in
day,
commercial.
There is no time is running out, my lord.
That's
Next
the
one-
risk you face in the commercial. We are not
Beg
inclined,
pardon, my
not
lord.
satisfied. Sorry.
Your lordship, it is a question of interpretation, my lord.
You want us to affirm, you want us to affirm the interpretation made by the single
No,
bench?
my lord.
We'll do that.
My lord, when attorney.
No, otherwise also, madam,
Simple English,
whether the LOA is,
understand simple English, my lord.
Madam.
Attorney is written here. Attorney is written in the, my lord, documentary form, point number 5, that my lord certificate to be given by attorney. So, my lord, when attorney is given, where is the fault, my lord? Otherwise, the
please read.
conditions are okay.
Have you got the instructions to tenderers? Have you got that?
Yes, my lord.
Instructions to tenderers.
Yes,
Where
my
is it filed part of record?
Yes, my
Read,
lord.
please.
Here I have annexed
Appendix
that
3,
clause.
read
That clause.
clause
have-
A4,
I have-
A6.
Yes,
A6.
open tender.
Where is it, please?
Yes, my lord, that clause. Your lordship is
A6.
talking about clause.
A6,
A6.
A6. Have you filed it on record? No. Read,
Held it, my lord. It is there, my lord.
read, please.
Yes. Yes, my lord. Page 7, your lordship talking about, my lord.
Instructions to tenderers. Appendix 3. Give these documents. Madam.
Yes. 19. Yes.
No, it's not.
In case, upon instruction
Yes.
to tenderers.
Yes, read
In
clause
case
6.
in case any information submitted by tenderer is found to be false or incorrect at any time during process for evaluation of tenders, it shall lead to forfeiture of that.
That is
tender
4. We
which is
we are referring to 6, madam, down below that. 6.
6, yes. The tenderers shall submit a certificate stating that they are not liable to be disqualified and all their statements, documents submitted along with that too. And factual standard format of the certificate to be submitted by the bidder is enclosed as Annexure 5 in addition to Annexure 5. In case other than company proprietorship firm, Annexure VA shall also be submitted by the each member of a partnership firm. joint
Each
venture.
member. So each member has to give a separate certificate. Then come to page number 30 of this document. Five point two.
The tenders shall submit a certificate stating that they are not liable to be disqualified, all their statements, documents. It is actually submitted but signed by one person since it's a power. of
Each
attorney.
member has to give a separate form. That is what the requirement is. If you don't comply with it, you had to be disqualified. There can't be any two views about it. Thank you.
On that particular ground, Lordship, we have rejected 3 tenders.
Dismissed. Thank you, madam.
I'm Ujjwala.
And counsel for the
Whether-
petitioner craves liberty to withdraw the
whether-
instant writ appeal, seeking leave that she may be allowed to pursue the pending writ petition before the learned single judge. Accordingly, in view of the submissions who made, the instant writ appeal as well as the connected interlocutory application are dismissed as withdrawn with the liberty prayed for. Thank you.
Item number 29.
ये वापस लौटा देना। Yes, please. What is the PIL about?
My lord, this PIL is about the mass plantation drive that was being conducted by the government of Assam recently in the name of the scheme Amrit Riksha Andolan. So, my lord, according to this scheme, they wanted to make a Guinness World Record by choosing different locations. Now, before going to the whole scheme, my lords, I first want to come to one of the site
Yes.
that is called as Abhayapuria Gaon. Now, my lord, Abhayapuria Gaon's proximity is to the Dihing Patkai National Park. It is just adjacent and touched with the Dihing Patkai National Park. Now, my lord, what happens is that on August, the government of Assam officials came to the villagers to show them the vacant plot of lands where they can actually plant the trees. On 8th of September, the PCCF, along with other officials and the concerned MLA of this constituency, they came and then they made an observation which the villagers are not aware about. However, on the night of 11 September, now it's one of its kind that now bulldozers are also being used to eradicate plants. So on one,
Bushes. Basically, they have cleared bushes.
No, my
to
lords.
create a plantation ground.
No, my
That's
lords.
what they have done.
No, my lords. They have.
Have a seat, Mr. Gogoi. We'll hear you.
Yes. No, my lords. We have. I'm grateful for what has fallen from my lords. We have annexed some documents, my lord, for that. Annexure 5, page number 40 to 47.
Yes.
If my lords see page number, no, we could not give video evidence. They have uprooted, my lord, neem trees, big neem trees. They have uprooted
I
bamboo
don't see
plants.
a single neem tree, gentlemen. As a matter of fact, after coming to Assam, I personally have not seen a single neem tree. As we see in Rajasthan.
My lord, there are. We can submit video evidence also. My lord, if you come to para 42, my lords. Sorry, page number 42. There are also betel nut trees. What has happened, my lord? The pictures, the video evidence are quite small in number. The reason being that, my lord, when this operation is being conducted, they were all surrounded by police officials. Not even a single person was allowed to enter. Someone somehow put sneaked in
So
and
they have,
the photograph.
if they are putting up, they are planting commercially viable trees or commercial value trees, what's wrong in it?
Yes, my lords. And
They have not approved it from trees from the declared forest or reserve forest. That's right, government plots. What is the problem for you?
yes, my lords. I'm
Yes.
grateful. My lords, when
We'll bind them down, that look after the trees, ensure that the newly planted trees come up very quickly.
I'm
Okay,
grateful, my lords.
we'll do that.
I'm grateful. But the problem here is
Hmm.
in the teeth of the judgment of the order passed in TR Govardhan.
Godavaram. Yes.
What happens, my lord, is that the eco-sensitive zone
Hmm.
is to be 1 kilometer from.
Has it been declared? Have they removed trees from the ESZ?
Yes,
Tell
my
us, let us show the notification
Which notification, my lord?
declaring this area from where the trees have been removed to be in the part of the ESZ. Satisfy us on that.
Yes, my lords. ESG, what has happened, my lord?
Yes.
Dihin Patkai National Park was been declared as national park only in 2020.
Hmm.
So what happens, my lord? Economic sensitive. So for a declaration of economic sensitive zone,
Yes.
they have to send a proposal to the Ministry of Environment, Forest and Climate Change, Government of India.
Yes.
So, my lord, there's a 3rd June order 2022, which says that if you don't send any draft proposal,
Hmm.
the ESZ would be 1 kilometer from the borders of the
Yes.
of the national park.
Yes.
However, that was modified later on, which said that this order would not apply if you have if the draft proposal or any final proposal has been uploaded by the Ministry of Environment and Forest and
This
Climate
is all a question of fact, whether this plantation or what you say, deforestation, what you allege,
Yes, my lord.
is within that 1 kilometer boundary.
Yes, my lord. That is one of the.
How do we establish that? How do you satisfy the court that it is within 1 kilometer?
Yes, my lord. We have brought some whatever limited resources we had, my lord.
Yes,
We
you have
have
to
brought
make
some-
research, for PIL,
Yes,
there has to be a proper research
Yes, my
and
lord.
research material has to be filed on it.
Yes, my lord. We
What
have
is the material? Let
we
us
have
see.
we have annexed, my lord, some aerial maps.
Hmm.
My lord, that is in
First, come out with your pleadings that this is within that eco-sensitive zone.
my lord, that's the problem here. The problem here is that, my lord, when they have not sent any draft proposal to.
So first you file a writ petition saying that they have to send a follow-up petition, require that compliance to be done. Then come to the court with this kind of writ petition.
No, but here, my lord, when they don't send any draft proposal, it has to be 1 kilometer from the national park.
So now satisfy us that this is within 1 kilometer.
No, we have annexed some maps to that, my lord.
Yeah.
Page number 54, my lords.
Yes, let's see.
Page number 54, my lord.
Hmm.
If you see, my lord, this is Abhaypuria Gaon. On the right hand side to it is the Dihin Patkai National Park, my lord.
Hmm.
This is just adjacent. And
Hmm.
also, my lords, this is also adjacent to the Dihin Patkai Wildlife Sanctuary, Elephant
Yes.
Reserve. And this is
Where has this plantation taken place?
just adjacent to that, my lord.
Oh, show us from the pictures, these very pictures. There must be later pictures. What Google pictures you have taken
No,
down,
no,
satellite pictures, what you have taken down,
is
so that
satellite-
this should be evident from these very pictures
That-
where
that's
the
what, my lord.
plantation took
Satellite
place.
pictures, what happens, my lord, it takes time to upload. Therefore, my lord, if
So
the
you wait for that, then get a latest picture.
But if the cognizance is not, ma'am, if indulgence is not done right now, my lord, then there could be bigger devastation because the plantation is 180 because of land, my lords.
Nothing to satisfy the court right now, sir.
My lord, kindly see paragraph page 31. The species of plant trees being planted.
Hmm.
At the bottom, my lord, mahogany, ogoru, titasopa, bogisopa. My lord, these are forest trees.
Hmm.
My lord, see, kindly come to page 1114.
Hmm.
They have filed a representation before, and what this letter explains, my lord, they are into commercial exploitation of that forest land by, my lord, rubber plantation,
Oh,
bamboo plantation, tea gardens.
okay, okay.
Lord,
And they have admitted this is a government lands, my lord.
my lord, but however, there are also grazing lands there. If they have uprooted the trees in the grazing land also, then.
If is not a submission in a
No,
PI.
but they have. It's
Where is the submission? Where is the submission written in your pleadings that they have approved something in the grazing lands?
My lord, then let us allow my lord to file further
Do
evidence.
that,
my lord.
who stops you? Counsel for the petitioner. Praise for and is granted 4 weeks time to bring additional material on record.
May I pray your lordship? Lordship, in this matter, revenue department, though it is reflected in the cost list, revenue is not made a party in the main PIL petition, your lordship.
He shall also implead the Department of Revenue as a party respondent in this. case.
My lord, there is an unlisted permission was given, I think possible.
Production list, item 1.
May it please your lordship. My lord, what happened in this case, we are assailing an NIT issued by the government of Nagaland, my lord. Now, our basic challenge, my lord, having regard to the terrain of the state, my lord, we are putting this aspect into challenge. Now, our first ground of challenge is, my lord, as per the PMGSY guideline, my lord, all this thing has to be done by a committee called State Level Committee. That is prescribed. If your lordship will kindly come to page 42, my lord.
You are aggrieved by
Clubbing of the, my lord.
no. What is the order under
No,
challenge?
my lord, we are aggrieved by non-passing of interim order by the learned single judge. Now, my lord, the interim order which we are seeking for is, my lord, in the pre-bid meeting, my lord, we have raised those questions. My lord, normally the precedent is, my lord, they will answer to those. Either they reject or they accept. Now, in this case, nothing was done. Then we file a representation, my lord. Now, basically, my lord, against one package, my lord, they have made certain packages, projects. Now, how is it possible to perform, my lord? Now, kindly come to, my lord, page number 42. Now, the manner in which the tender was put to, I mean.
We can
process.
at best observe, Mr. Chaudhary.
Yes.
The tender process shall remain subject to the outcome of the.
No, my lord, what I'm saying is, my lord, we have filed a representation. Let them dispose of the representation.
We are not staying any
No, no,
proceedings.
no.
without-
What I'm saying is, my lord, that today is the last date for receiving tender.
Yes,
Let
you-
them receive the tender. They will not finalize the tender without disposing of the
We can't
representation.
prejudge these things, no?
No, my lord, kindly see, my lord, the whole thing has been done by the chief engineer. It should have been done by a committee. My lord, the PMGSY guideline at page 42, please come to 42, clause 6.4. My lord, entire contractor association is before your lordships.
Yes.
The state level standing committee,
So with the notice,
SLSC,
Mr. Chaudhary,
yes.
we'll request the learned single judge to take a decision quicker. Expedite the hearing of the petition. Nothing beyond that.
No, my lord, today is the last date for
So
submission.
you
of the-
submit your tenders, what
No, no,
stops?
no, what I'm submitting is. my
Yes.
lord, let them dispose of our representation within a period of 10 days.
You are appearing,
For
madam?
for a period of 10 days, my lord.
Yes. What
for
do
a-
you say?
For a period of 10 days, they will not do anything, my lord.
Oh,
That's
we-
my only prayer. And my representation is at page 72, my lord.
What have you done about their representation?
They have not
Madam?
done anything.
Yes. So all right, you come back with your instructions on Monday. At this stage, without issuing notice to the respondents, we record presence of madams. Your good name, please. On behalf of the respondents numbers, State of Nagaland, respond number 1, Commissioner and Secretary, Government of Nagaland, respond number 2, and the Chief Engineer, PWD, and empowered as officer, respond number 3. She shall take instructions on the submission of the petitioners that the representation dated 6/9/2023 submitted by the petitioners has not been decided till date, and the tender process is being finalized. List on Monday.
Deeply obliged.
Hmm.